don't fret. If there's a problem, I'll simply direct the timekeepers to stop the clock. It's really that simple. Timekeepers, you're serving an important function. Do not fall asleep at the switch. You've all done a great job so far, and I know you know the drill, but basically we need you to keep us on schedule, use the chat feature, or show up on the screen with the time. It's important that we don't end up at the end and have some kind of dispute over how much time's remaining. One rule that I do need to highlight is that we are really concerned and interested in making sure that the only people who are communicating during the competition with the students are members of the team that are appropriate. So for instance, the 3 student attorneys, they can be texting, emailing, whatever, back and forth. But this is not an opportunity for parents or siblings, especially siblings, or friends to somehow slip notes or try to get word to people. And coaches, you've coached them, let them do it now. You need to just kind of step back and have faith that they know what they're doing. And trust us, if they made it this far, they know what they're doing. All right, with that, I'll just note for the spectators, we're happy that you're here. This will be on YouTube live, and it can be viewed later. And we're really excited about this opportunity for you to share in this. Now, I'm going to turn it over to my colleagues here and ask them to briefly identify themselves. And then I'll finish with an introduction and we'll get started. On my screen, I have Judge Fisher next. Do you want to just introduce yourself?
Sure. Well, good afternoon and congratulations to both teams. I'm William Fisher. I'm a federal bankruptcy court judge in St. Paul. And prior to that, I worked in Hennepin County with Judge Cook. And prior to that, I was in private practice. And so again, congratulations to both teams. I look forward to seeing this.
Yeah, I was actually Judge Fisher's mentor for all of about 6 months before he jumped to the federal bankruptcy court. So I drove him away.
Yeah. People blame you all the time for that.
Yeah.
Go ahead.
Okay. Next, I have Winnie Reese.
Hi, all. It's great to see you again. I've seen both teams at different points throughout the season and past seasons, and it is wonderful to see you here. So many congratulations. I am the chair of the program. I also am in private practice in civil, corporate, intellectual property, mergers, acquisitions, and represent a heck of a lot of wedding vendors. So it is interesting to see all of you here today arguing this case. So thank you again, and I wish you the very best of luck.
And I think Winnie might be taking lessons or notes from all of you for your arguments so she can use them with her clients. Next, we're really happy to have the MSBA president with us, and I'll turn it over to you.
Thank you. Yes, my name is Diane Ebert, and I am the current president of the Minnesota State Bar Association, the sponsor of this program. So congratulations, everyone. I did have the opportunity to speak with you all during the banquet an hour or so ago. So I will again reiterate on behalf of the Bar Association just how proud we are of your participation in this program. When I'm not serving as the MSBA president, or perhaps I should say as I'm serving as the MSBA president, I also have a private practice with a law firm in St. Cloud, Minnesota called Quinlivan and Hughes. So again, congratulations.
And it's a great firm with a great reputation, and it's because of attorneys like MSBA President Diane Ebert. And this is the type of thing that the MSBA is the only statewide organization for attorneys in the state, and it's great to come together and look at perhaps the next generation of law students and attorneys. And now, with no further ado, Judge Dean.
Yeah, thank you, Judge Cook. Folks, I'm either the father or grandfather of mock trial. I've been involved in it since 1988, started the team in Cambridge Isani High School, coached it for 17 years. And since 1992, probably going back to when your parents were in high school, I started judging both at the state and national level, and wrote the national case when Minnesota hosted in 2002. It's a pleasure to be here. It's and hats off to your teacher coaches, lawyer coaches. I know how hard they've worked and how hard you've worked. Good luck.
And finally, I'm Bill Cook. I'm a Hennepin County judge. And I've been a judge now for about 13 years, but I've been involved with mock trial for a really long time. Probably the last 25, 30 years or so as a judge. And I did coach for a few years, so I do know what the coaching is like. And I'll echo Judge Dean's comments, thanking the coaches. But hey, it's all about the students, and we're about to introduce them and see what they have. I'm going to ask the Eagle Ridge Academy folks for the plaintiff to please come on screen. And I'll ask my coaches to go ahead, or my judges to go ahead and you can exit. Thanks. So you're a team of one, it looks like. We can have your whole team come on if they would. Thanks. Give you all a little bit more screen time. So, all right, if I could go ahead and have the Eagle Ridge team introduce yourselves and tell us what roles you're playing.
Good afternoon, Your Honor. My name is Bella Vanderlucht. I will be conducting the direct examination of Jordan Knox as well as the cross-examination of Chris Nixon. And my co-counsel?
Good afternoon, Your Honor. My name is Henry Long. I will be delivering the opening statement as well as conducting the direct examination of Peyton Knox and the cross-examination of Bobby Stewart.
Good afternoon, Your Honor. My name is Edward Manuskin, and I will be conducting the direct examination of Riley Swain, the cross-examination of Tony Olivia, as well as delivering the closing argument.
And our witnesses.
Good afternoon, Your Honor. My name is Ellesmere Foley, and I will be portraying Riley Swain.
Good afternoon, Your Honor. My name is Natalie Grube, and I will be portraying Jordan Knox.
Good afternoon, Your Honor. My name is Muthu Meenakshi Sundaram, and I'll be portraying Peyton Knox today.
And our timekeeper.
Good afternoon, Your Honor. My name is Greta Long, and I will be the timekeeper for the plaintiff this afternoon.
Great. Well, nice to meet you all, and good luck today. Now I'm going to kick you off. If we could have Apple Valley join us, please. All right, 1, 2, 3, 1, 2, 3. Are we missing one or no? There we go. Okay, great. I thought my math would be right that we would need one more. If we could go ahead and have the attorneys note your appearance for Apple Valley, please.
Yes, Your Honor. Good afternoon, Your Honors. My name is Maya Gort. I'll be conducting the direct examination of Tony Olivia, the cross-examination of Peyton Knox, and the closing argument on behalf of the defense. And my co-counsel?
Good afternoon, Your Honors. My name is Julie Congdon. I will be conducting the opening statement as well as the direct of Bobby Stewart and the cross of Jordan Knox.
Good afternoon, Your Honors. My name is Taylor Garrison. I will be performing the direct examination of Chris Nixon and the cross-examination of Riley Swain.
And our witnesses.
Good afternoon, Your Honors. My name is Adam Hahn, and I will be portraying Tony Olivia.
Good afternoon, Your Honor. My name is Emily Bauer, and I will be Bobby Stewart.
You're muted.
Sorry, Your Honor.
That's
Good
okay.
afternoon, Your Honors. My name is Jordan Clinton, and I will be portraying Chris Nixon.
You're just
And our
showing everyone how easy it is to mute and unmute. So that's good.
And lastly, our timekeeper.
Good afternoon, Your Honors. My name is Alexis Burrish, and I will be the timekeeper for the defense.
Okay, great. Well, nice meeting y'all and good luck today. I know everyone has worked hard. All right, so we do have some preliminary things to talk about. I'll go ahead and invite an attorney from each side to discuss any preliminary matters.
Yes, Your Honor. Pursuant to Rule 3.4, may we waive the reading of the pretrial stipulations?
Please.
And how would you like us to state our objections? Would you like us to state the name of the objection and wait to be heard, or provide some basis for our objection?
You can just state the name of the objection, identify it, and then maybe 1 or 2 words, but it doesn't have to be a lengthy thing. I'll hear from the opposing counsel, and I will always come back. You don't have to ask me if you can be heard. I'll always come back and hear from you.
Yes, Your Honor. With that, the plaintiff is ready to proceed.
Okay, great. And do we have someone from Apple Valley? Anything from Apple Valley for the preliminary matters?
Yes, Your Honor. First, since this is an online trial, we ask that if at any point you cannot see or hear us clearly, you interrupt us so that we can remedy the situation.
Certainly. And I would ask the same of the students. Let us know.
Yes, Your Honor. With that, the defense has nothing further.
Okay. Well, let's have fun and see how this all goes. If the plaintiff is ready with its opening statement, you may come on screen, and then I'd ask the defense opening statement, the attorney to come on screen as well. Okay. Mr. Henry, or Mr. Long, I'm sorry. We'll go ahead and turn it over to you.
Yes, Your Honor. Members of the jury, today's case is about catering, capacity, and cost. On July 4th, 2020, Peyton Knox and Parker Stevenson were supposed to have a beautiful wedding. But today, you'll hear that their picture-perfect wedding never happened. Not because of the pandemic, but because the defendant, the Nixon Lodge, failed to uphold their end of the deal. Today, you'll hear how the Nixon Lodge breached their contract by failing to abide by the agreed upon catering, capacity, and cost. Let's begin by briefly talking about the law that governs today's case. Our client, Mr. Peyton Knox, has chosen to sue the Nixon Lodge for breaching the contract that both parties signed back in June of 2019. As a result, we've incurred a burden. This means that we need to prove that it's more likely than not that the Nixon Lodge broke the contract and that Peyton Knox did not. Now, to understand exactly how the Nixon Lodge broke their contract, we want you to focus on three aspects of the wedding: the catering, the capacity, and the cost. When COVID-19 swept across America, venues everywhere were forced to close. The Nixon Lodge was no different. Then, on June 1st, 2020, the Nixon Lodge was allowed to reopen under restrictions from the Minnesota Department of Health. But you'll hear that the following day, the owner of the Nixon Lodge sent an email to Peyton Knox explaining that they were imposing even further changes onto his wedding. The first unreasonable change to the contract was in regards to the wedding's catering. In the contract, the Nixon Lodge promised catering, which included a high-end dinner, hors d'oeuvres, and open bar. But then, just a mere month before the wedding, you'll hear that the Nixon Lodge canceled all of the food and drink for the entire event. This restriction was nowhere in the Minnesota Department of Health COVID-19 guidelines. To add insult to injury, the Nixon Lodge has chosen to sue our client to pay for the food that they refused to serve. Now, the second unreasonable change to the contract was in regards to the wedding's capacity. In the contract, the Nixon Lodge promised a capacity of 250 people. However, because of COVID-19, the Knox party had to cut their guest list to 175 to comply with the governor's order. But then, just a mere month before the wedding, you'll hear the Nixon Lodge told my client that they'd have to cut an additional 100 people off of their guest list. The only justification that the Nixon Lodge has provided for this change was because they refused to repair their outdated ventilation. Now, frustrated with these restrictions, the plaintiff asked the Nixon Lodge if they could reschedule to a later date. But the Nixon Lodge had one more promise to break regarding the cost to reschedule the wedding. The evidence will show that when the couple asked to reschedule, the Nixon Lodge imposed a $3,750 fee. A fee which was nowhere in the terms of the contract. Now, in a moment, Ms. Congdon is going to come before you and try to excuse the Nixon Lodge's unreasonable changes by scapegoating the force majeure clause of the contract. Essentially, she'll argue that the Nixon Lodge could just disregard any part of the contract so long as they blamed COVID-19. But members of the jury, that's just not how force majeure clauses work. Rather, the evidence will show that the Nixon Lodge didn't even attempt to make reasonable efforts to uphold their end of the deal. Now, members of the jury, throughout today's trial, we want you to focus on the breaches surrounding the catering, the capacity, and the cost for the wedding. And at the end of today's trial, my co-counsel, Mr. Edward Mnuchin, will come before you and ask you to find the defendant, Nixon Lodge, liable for breach of contract and the plaintiff, Peyton Knox, not liable for the same. Thank you.
Thank you very much. The defense may proceed.
Yes, Your Honor. Reasonable restrictions. May it please the court, opposing counsel, members of the jury. The Nixon Lodge is a small business right here in St. Louis County, and they've been a part of our community since the 1950s. They've held thousands and thousands of weddings and events, and they've brought love and happiness to countless of couples. But due to the recent coronavirus outbreak, the Nixon Lodge is faced with a very difficult question. How do we continue to hold weddings safely in the midst of a pandemic? Their answer to that was reasonable restrictions. Today, Peyton Knox is suing the Nixon Lodge over these restrictions, claiming that they are a breach of contract. The Nixon Lodge is counterclaiming that it's actually Peyton Knox who breached the contract. But it's up to you, members of the jury, to decide who is right. Today's case really boils down to three important questions. One, did the Nixon Lodge fail to perform an important part of the contract? Two, if so, is there a section in the contract that excuses an event like this? And three, if not, was it actually Peyton Knox who breached the contract through missing a payment? By the end of the trial, you have all the information that you need to answer these questions. But first, let's start at the beginning. In early 2019, Peyton Knox and Parker Stevenson were looking for a venue to host their wedding. And on June 19th of 2019, they found the Nixon Lodge. The couple fell in love with the lodge. The rustic look, the amenities, as Peyton Knox would put it herself, the Nixon Lodge was perfect. Before the couple left the venue, they signed a contract with the Nixon Lodge for them to host their wedding on July 4th of 2020. Soon afterwards, the couple then met up with Nixon Lodge caterist Bobby Stewart to discuss the menu for the wedding. Ms. Stewart would like to tell you that she likes to find a special food or drink that really means something to them. Ms. Stewart will share that upon learning the groom-to-be's family was from France, she suggested black truffles. The couple fell in love with the idea. Today, you'll be hearing a lot about these truffles. The evidence will show that black truffles are considered to be a special order item. They're very rare, expensive, and have a very short shelf life. All of this information was communicated to the couple, and the contract required for these truffles to be paid for at the time of signing. Now that the wedding date was determined and the special order items were established, the Nixon Lodge got straight to work. The evidence will show that Miss Stewart found a small distributor off the East Coast that specialized in wild mushrooms. And through this distributor, she found a small farm in southern France that sold black truffles. Evidence will show that she paid $8,000 for these truffles and an additional $1,000 for their proper storage so that they'd be perfect for the wedding. But in March of 2020, everything changed. The coronavirus pandemic began to hit the state of Minnesota. The Nixon Lodge was shut down and the Knox wedding was in jeopardy. But on June 1st, there was hope. Businesses in Minnesota were allowed to reopen, subject to several government restrictions. The evidence will show that these restrictions included limiting the number of guests at wedding, requiring guests to have social distancing of 6 feet apart, and requiring venues to come up with a preparedness plan. And the Nixon Lodge did just that. Now, this is where you, members of the jury, come in hand today. Peyton Knox says that these safety rules that the Nixon Lodge implemented are a breach of contract. but there's actually part in the contract that excuses an event like this. As Mr. Long referenced earlier, it's a force majeure. Force majeure is just a fancy way of saying that an event cannot be anticipated or controlled. A force majeure can be an act of people or an act of nature. Both parties today agreed that under the event of a force majeure, either party is excused from completing their remaining performance under the contract. What is up for you, members of the jury, to decide is whether COVID-19 qualifies as a force majeure event. To make this determination, the law boils down to three important questions. One, was the coronavirus pandemic beyond the control of Nixon Lodge? Two, did the coronavirus pandemic cause issues in performance of the contract for the Nixon Lodge? And three, did the Nixon Lodge continue to perform to the best of their ability? By the end of the trial, you will come to find that the answers to these questions are yes, yes, and yes. And that's why at the close of this trial, my co-counsel, Ms. Maya Gort, will come before you and hold the Nixon Lodge harmless for the reasonable restrictions. Thank you.
Thank you very much. And as soon as we get resettled here, the plaintiff may call its first witness.
Plaintiff calls Riley Swain to the stand.
All right, you may begin.
Please introduce yourself to the members of the jury.
My name is Riley Swain.
And what do you do for a living?
Well, I'm a wedding planner. It's been my dream job ever since I first watched my best friend's wedding with Julia Roberts when I was a little girl. Now I own my own wedding planning business. It's called Swanky Weddings, and it's kind of a play on my last name.
So when did you first meet the plaintiff, Mr. Knox?
I first met Peyton to begin planning his wedding on March 14th, 2019. His story was so romantic. It just made me want to give them the best possible wedding experience.
I'd like to walk through your wedding planning process. So when you're working with a new client, what's the first thing you do?
My first step is usually to talk with the client about what their interests are, get a sense of their romantic history, what their relationship is like. I love hearing about all the cheesy first dates and proposals. It's my favorite part of my job.
So what did you talk about with Mr. Knox?
We talked about the date, July 4th, 2020. It was going to be their 5th year anniversary, and it was so
Objection, Your Honor, lack of foundation.
Okay. Counsel, any response?
I would ask what foundation has not been laid.
Ms. Garrison, where do you feel foundation is lacking?
Yes, Your Honor. The proper foundation has not been laid as to how Riley Swain knows it was Peyton Knox's 5-year anniversary with Parker Stevenson. That foundation has not been laid, and Ms. Knox has not testified yet. Therefore, this foundation has not been laid, and it's lacking foundation.
May I respond?
Yes.
The witness has just testified that she discusses the client's romantic histories when planning a wedding, and I have asked the witness what she talked about with Mr. Knox. The foundation has been laid as to how she would know that July 4th was Mr. Knox's 5-year anniversary.
Okay, I'm going to overrule the objection. I feel a proper foundation has been laid. You may proceed.
Ms. Swain, what did you talk about with Mr. Knox?
We talked about the July 4th wedding date. It was their 5th year anniversary, and it held a lot of significance to the couple. In fact, their story was so magical, they wanted their whole wedding to revolve around July 4th. Some ideas we also talked about were a red, white, and blue floral arrangements, as well as a red, white, and booze cocktail bar.
So once you have the date and theme, what's your next step?
I knew venues would start booking up very quickly. I mean, July 4th is a very popular date. So I started reaching out to ones that I thought might work for the couple.
And what venue did you settle on?
I found 3 that would potentially work. And after touring all of them, they ended up choosing Nixon Lodge and Catering, which was perfect because it had plenty of space for all their guests.
How many guests were there going to be?
The total guest count was looking to be about 250 people.
So once you have the guest count, what other details are there to take care of?
Well, planning a wedding is not easy. Let me tell you, the amount of mood boards I have on my Pinterest alone, it's crazy.
Objection, Your Honor, relevance.
Okay, I'm gonna overrule the objection. She's just talking about the job that she's doing. I'll allow it. You can go ahead, counsel.
Ms. Swain, what other details are there to take care of?
The next main step after the guest count in the venue is figuring out the catering. So Nixon Lodge required we hire their in-house caterer. I think her name was Bobby Stewart, yeah, and she worked with the couple to decide on a menu option.
And at the end of your process, how do you finalize all your plans?
The couple had to sign a contract with Nixon Lodge as well as pay a down payment.
What was the down payment?
All told, the Knox couple put down a total of almost $70,000. That included the venue rental expenses.
Objection, Your Honor, relevance. May I explain?
Yes.
Your Honor, this case is bifurcated. Therefore, any dollar amount on expenses is not relevant in today's case.
Okay, any response from plaintiff?
Yes, Your Honor. This case is bifurcated as it relates to liability and damages, but this testimony is not being used to show damages incurred by the plaintiff. It's merely being used to lay the foundation of what was in the contract that the two parties signed, which is relevant to today's case.
Anything else from the defense?
Yes, Your Honor. Although there may be a minimal amount of relevance to say that there were expenses, the specific amount of what those expenses were are not relevant as the case is bifurcated.
Okay. I'm going to overrule the objection. I do believe it's relevant on the issue of reasonableness, which is perhaps a central issue of the case. You may proceed.
Ms. Swain, how much was the down payment?
It was almost $70,000, and that included the venue rental expenses as well as the food and beverage down payments.
Ms. Swain, I'd now like to talk about what happened when COVID-19 hit. How was your job affected?
Well, the whole wedding industry was completely turned on its head. I mean, there were so many new restrictions and guidelines we had to take into consideration, and everything was so unexpected. I hate the unexpected. I mean, I never even leave my house without my to-do list.
You mentioned some new restrictions. What were these?
The Minnesota Governor, Tim Walz, mandated a capacity of 175 people for venues.
Objection, Your Honor, lack of foundation.
Okay. And counsel for the defense, where do you believe foundation is lacking?
Yes, Your Honor. The proper foundation for this testimony is lacking as to how Riley Swain is familiar with these government restrictions. To be able to testify about these government restrictions, the proper foundation needs to be laid, that she is familiar with them, how she is familiar with them, all of that information.
Okay. I'm going to sustain the objection and just ask the plaintiff's counsel to lay some foundation for the knowledge.
Yes, Your Honor. Okay. Ms. Swain, were you familiar with the government restrictions surrounding the COVID-19 pandemic?
Yes, I was. They're very important to my job.
And what did these restrictions state?
Venues had a capacity of 175 people, and guests would be required to socially distance and wear masks. But the wearing masks wasn't a problem because I found the sweetest ones on Etsy, and they're perfect for weddings.
So how did Nixon Lodge react to the government restrictions?
The strange thing was they imposed even more limitations, and they went even further by cutting the whole guest count to just 75 people and canceling all the food and all the drinks.
Objection, Your Honor, lack of foundation.
Well, I'll hear from the plaintiff's counsel.
Your Honor, the foundation has been laid that this witness was the wedding planner for this specific wedding, which means that she worked with Nixon Lodge, and therefore she reasonably would know about Nixon Lodge's restrictions in regards to this wedding.
I'm going to overrule the objection. You can certainly cross-examine if you think that there's something that she has wrong, or if the witness, if you believe that any foundation is not properly there. But the general role that she played, she would have this as her fund of knowledge. I'll go ahead and overrule the objection.
Ms. Swain, what new restrictions did Nixon Lodge implement?
They imposed a capacity of just 75 people, and they went even further by cutting the whole menu, including all the food and all the drinks.
So how would these restrictions have impacted your client's wedding?
Well, it certainly wouldn't be the dream wedding my clients had planned or paid for. It meant they could only invite their close family and friends. And with no food whatsoever, it seemed like it was going to be a cheap imitation of the original wedding.
So with all these changes, did Nixon Lodge at least keep you updated?
Barely. They didn't reach out at all from March to June to keep us updated during the shutdowns. And we didn't find out about the restrictions until 1 month before the wedding. 1 month. And after that, there was another period of about 2 months in which emails just went completely unanswered.
Did Nixon Lodge at least offer alternative options for the wedding?
No, I was the one who had to reach out to them and offer and ask them to suggest some alternative dates. Only then did they suggest either rescheduling into October or into 2021, but they said that an additional fee would apply.
What was the additional fee?
It would be an extra $3,000.
Objection, Your Honor, lack of personal knowledge. May I explain?
Yes.
Your Honor, this witness is not familiar with the contract itself. She may have specific random information regarding what may be contained within the contract from working with Peyton Knox, but she does not have the personal knowledge to testify as to what was in the contract in particular. Also, the foundation has not been laid as to how she would know this information within the contract.
May I respond?
Certainly.
The witness has not testified about the contents of the contract. She's testified about the rescheduling fee that Nixon Lodge imposed.
Anything else from the plaintiff or the defense on that?
Yes, Your Honor, the rescheduling fee would be contained within the contract. To know whether or not that rescheduling fee existed, you would have to have knowledge of the contract. Ms. Swain does not have knowledge of this contract. She was not involved in the contract process.
Okay, well, those are two different things, being involved in the contract process and knowledge of the contract. But the question only asks if there were other things that were done. And the witness answered there was a $3,750 fee that was added. I'm going to overrule the relevance or the foundation objection to that question.
Ms. Swain, how much was the additional fee?
It was an extra $3,750 on top of what the couple had already paid for.
And was this fee expected?
Not really. We were moving the date from a highly sought after summer holiday, which was an essential part of the couple's dream wedding, to a cold Friday in the fall, which really held no significance to them whatsoever, and they wanted to charge extra for this downgrade.
So besides that, did Nixon Lodge offer you any other options?
No, they didn't.
Thank you, Ms. Swain. No further questions.
All right, thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yeah.
Ms. Swain, you claim that the Nixon Lodge was unreasonable because they refused to negotiate, correct?
That is correct. I do think they were a bit unreasonable.
Let's evaluate that. You asked the Nixon Lodge to provide new dates for the wedding, correct?
Yes, I did.
And the Lodge provided new dates, didn't they?
Yes, a date in October or into 2021.
In fact, the wedding was moved to the October 23rd, 2020 date, correct?
Yes, that's what my clients wanted.
You had also asked for more guests at this wedding, right?
Yes, I thought that the capacity of 75 was a bit overly restrictive.
And the Nixon Lodge actually offered more guests, didn't they?
Yes, they offered to bring up the guest count up to 100 guests, but that was still 150 guests less than the original wedding.
Regardless, that is a yes to my question.
Yes, that's a yes.
But this guest count was not acceptable to you, was it?
My clients didn't really agree with the guest count.
After all, the couple said that they wanted 175 people for this wedding, right?
That's correct. That's what the governor had said was safe, and so they wanted to follow that.
In fact, you described the couple as adamant about getting 175, right?
Yes, I did. I mean, 250 guests is quite a lot of people, and they wanted their wedding to be safe. And since the governor had said 175 were legally allowed, they wanted to move their guest count to 175.
They told you that if they didn't get this number, that they would cancel, correct?
Yes, that was one possible option, they told me.
So you contacted the Nixon Lodge, right?
I did.
And you told them that it would be perfectly fine to move forward with 175 guests. Is that correct?
That is correct.
I want to evaluate what you base that opinion on. You aren't a scientist, are you?
No, I'm not a scientist.
You're not a public health expert?
No, I'm not a public health expert.
Nor a doctor?
Not a doctor either.
You've never studied COVID-19 in particular, have you?
No, I haven't.
And you've never studied any diseases in general, have you?
No.
You have never examined the airflow at the Nixon Lodge, have you?
No, that wasn't one of the things that I did when I went there.
So you personally aren't qualified to assess whether or not 175 is safe for the Nixon Lodge in particular, are you?
I was just going with what the governor had said was safe.
Ms. Swain, that did not answer my question. You yourself are not qualified to make that assessment, are you?
I suppose not.
Next, I'd like to talk to you about the restriction on dancing. The Nixon Lodge limited dancing to just the married couple, right?
That is correct.
And you claim that the Nixon Lodge's restrictions on dancing went above and beyond the law, don't you?
Yes, it wasn't in the government restrictions that only the couple would be allowed to dance.
But Ms. Swain, doesn't the law hold that guests must be seated at all times with no mingling?
Yes.
So you thought the Nixon Lodge was being unreasonable to limit dancing when the law said guests must be seated at all times?
A little bit.
Thank you, Ms. Swain. I have no further questions, Your Honor.
Thank you. Any redirect based upon that cross-examination?
No redirect, Your Honor.
All right, you can step down, Ms. Swain. Thank you. And the plaintiffs may call their second witness.
Yes, Your Honor. At this time, the plaintiff calls Mrs. Jordan Knox to the stand.
All right, you may proceed.
Please introduce yourself to the members of the jury.
Good afternoon. My name is Jordan Knox.
Good afternoon, Mrs. Knox. What do you do for a living?
Well, my husband, Jim, and I used to run Palace Clothiers in downtown Hibbing for well over 30 years. We sold it though, I think 10 years ago now, and now we're just retired up here in Maine.
How are you related to Mr. Peyton Knox?
He is my son. He's actually pretty well known since he played for the U.S. Olympic hockey team.
What's he doing now?
Well, he was planning a wedding. He was getting married to Parker Stevenson. And I always knew that they were going to get married. She's such a sweet girl. Already feels like she's part of the family.
Objection, Your Honor. My apologies. I redact my rejection.
Okay.
Oh, let's talk about that wedding. Were you involved in planning the wedding?
Well, of course. Peyton is my only son. There's no way I was just going to sit back and let some stranger make all the big decisions.
Well, how did you start planning the wedding?
The very first thing that we chose was the date. Peyton really wanted his wedding to be on the 4th of July.
Objection, Your Honor. Lack of personal knowledge.
I'm going to overrule the objection. As the mother of the groom, I would think she has a pretty good way of knowing what her son would want. I'm going to overrule. The plaintiff may proceed.
Why did Peyton Knox want the July 4th date?
Oh, it was their anniversary. It was really sweet.
What did you do after selecting the date?
Well, you know what they say, location, location, location. So we booked the Nixon Lodge, the biggest venue in town.
Did you sign a contract with the Nixon Lodge?
No, Peyton did, though. It was his wedding after all. I didn't want to be a helicopter parent.
Did you read this contract?
Yes, I did.
Please turn your attention to Exhibit 2, located on page 50 of the case materials. Tell me when you get there.
Sorry, 1 second. Okay, I'm there.
Can you confirm that this is the contract that your son signed?
Yes, this is what Peyton signed.
Does it appear to be a fair and accurate copy?
Yes.
Changed or altered in any way?
No.
Your Honor, at this time, the plaintiff offers Exhibit 2 into evidence, the authenticity of which has been stipulated.
Any objection?
No, Your Honor.
Okay, exhibit 2 is received.
Now, Mrs. Knox, what did you agree to per this contract?
This just outlines how many people we were going to have and the food, and of course, when the wedding was supposed to be.
Talk about some of that. How many guests did you intend on inviting?
We were going to have 250 people, including the entire city council, as well as our dear friend Rick, who is the mayor of Hibbing.
What about the food for the wedding?
We ordered the nicest package that they offered. I think they called it their gold package. We were paying $36,000 for it, so I said, it better be gold.
And what was the date scheduled for your son's wedding?
Well, as I said, it was supposed to be on July 4th. We even paid extra to make sure it was going to be on that day.
Did the wedding end up happening?
No, it didn't.
Why not?
Well, after COVID, the Nixon Lodge started changing everything.
What do you mean by that?
They made changes to the guest count and the food and the venue and even the date. I mean, I knew we would have to change some things, but not as much as what the Nixon Lodge was wanting us to.
Let's go through some of these changes. How did the guest count change?
Well, they wanted to cut the guest count. At first they said 75, and I assumed they meant a percentage, but it turns out that was the total number of guests that they were allowing. That would mean we would have to cut the mayor. You can't just cut the mayor.
And how did the date change?
They say they can do it next year, and not even on the 4th of July. They start bringing up dates in January or February. Do they
Objection, Your Honor. Under Rule 403, this evidence should be excluded. May I explain?
Yes.
Rule 403 is known as more prejudicial than probative, but this rule also lists several other items in addition to prejudice that can be excluded after a balancing act. In this case, this evidence is substantially more misleading than it is probative. The evidence to support that is Ms. Knox is testifying that the Nixon Lodge rescheduled the wedding to the year after. That is not the case. That was not something that the Nixon Lodge was forcing to happen. It was rather an option that the couple had.
All right, any response?
Yes, Your Honor. Ms. Knox testified that the Nixon Lodge offered dates in the following year, not that they were forcing these dates upon the Knoxes.
Okay, I'm going to overrule the objection. You can certainly explore it in cross-examination if you like.
So, Mrs. Knox, how did the date change?
Well, as I was saying, they were offering dates in the middle of winter. Have they ever been through a Minnesota winter? Peyton loves hockey, right? I mean, don't we all? but I didn't think he'd want to get married in his gear.
Did you want to reschedule your son's wedding?
I mean, yes, if it meant that we were able to have more people. But then they sprung this rescheduling fee on us. It was almost $4,000.
Were you able to find this rescheduling fee in the contract?
No, nowhere. I mean, the only thing that's even close is a cancellation fee.
Had you canceled your son's wedding at this point?
No, I could not for the life of me figure out why they wanted to charge us that fee.
Mrs. Knox, at this point, how much money have you spent on your son's wedding that never happened?
In total, we spent about $70,000 on this wedding. All of that money. And for what? Nothing.
Thank you, Mrs. Knox. No further questions, Your Honor.
All right, any cross-examination?
Yes, Your Honor. May I proceed?
Yep, we'll get your timekeeper up. Okay, you may proceed.
On direct, you testified that the Nixon Lodge was charging for things that they were not providing. Ms. Knox, you said you were familiar with the contract, correct?
Yes, I have read it.
Your Honor, I ask that the witness pulls up Exhibit 2 if they already haven't.
Certainly.
Please open up to page 55 and let me know when you get to the deposit section.
Okay. You said the deposit section?
Yes, on page 55, Ms. Knox.
Okay, I'm there.
Please read along in your head as I read aloud. On or before the effective date of this agreement, the client shall provide a non-refundable deposit to the Nixon Catering to secure the date of the event. I read that correctly, didn't I?
Yes, you did.
On direct, you also mentioned the number 175. Ms. Knox, that number is a maximum, correct?
Yes, that's what the governor said.
So that means any number under the maximum
Objection, Your
follows.
Honor.
What's the
I believe I had a bit of a lag, but attorney testifying as Mrs. Knox never mentioned the number 175 on her direct examination.
I believe that she did mention 175. I'm going to overrule the objection, and it was anyway just leading into her question. You can certainly redirect if you want on that issue, but I'm going to overrule the objection.
Yes, Your Honor.
Ms. Knox, since that number is a maximum, that means any number under it follows the government restriction, correct?
I mean, yes, but if the Nixon Lodge only told us that they could have 2 people, it would still technically be complying with the governor's orders, but it wouldn't be right.
Now, Ms. Knox, I now want to talk to you about the expenses that the plaintiff is suing the Nixon Lodge over, the couture attire. You were the one that ordered this attire for the wedding, correct?
Yes, I did. Jim and I had some friends in the business, and so yeah, we got a discount.
You signed a contract, didn't you?
Yes, I did.
Your Honor, permission for the witness to pull up Exhibit 4?
Certainly.
What page is that on?
Exhibit 4.
Yes, what page?
Let me look for you.
And we'll stop the clock.
Exhibit 4 should be on page 67.
Okay, we'll start the clock.
Okay, I'm there.
This is a contract between you and Hibbing Haute Couture, correct?
Yes.
And it is fair and accurate?
Yes.
Your Honor, I now offer Exhibit 4 into evidence as its authenticity has been stipulated.
Any objection to Exhibit 4?
Yes, Your Honor. Relevance. This document is not relevant to the contract being debated today.
What is the relevance of this misconduct?
Your Honor, the plaintiff in their complaint lists the stress as an expense that they accrued, and in their prayer of relief, they're asking for reimbursement. It's obviously relevant since the plaintiff is suing for it.
Okay. Ms. Vanderloot, any response?
Yes, Your Honor. The plaintiff is suing. We, the plaintiff, are suing for the returnment of the monies that we paid to the to the Nixon Lodge, not for the Hibbing Haute Couture order. This document and the contract are not relevant to the breach of contract being tried today.
And Ms. Congdon, if they're not seeking recovery of the $17,100, do you believe it's still relevant?
Your Honor, if the plaintiff does not think that this makes the material issue more or less likely and that they would like to concede that they are no longer requesting the expense for this dress, we would be happy to drop the dress from the suit and just focus on the other fees.
May I respond?
Sure.
Your Honor, we were never requesting reimbursement for this specific money. If you look in the complaint, we are requesting reimbursement for the monies that we paid to the Nixon Lodge. The Hibbing Haute Couture money was never paid to the Nixon Lodge.
Okay. I'm going to sustain the objection that it's not relevant, but there's no conceding of anything. There's nothing that has to be conceded by either party, but Exhibit 4 is not admitted.
Yes, Your Honor. Ms. Knox, you claim it was unreasonable for the Nixon Lodge to ask you to cut guests for the letting, correct?
No, I knew we would have to cut some guests, but the amount that they made us cut was just unacceptable.
You wanted to have 250 people at the wedding, didn't you?
Well, I knew we couldn't have that much, obviously. I mean, I wanted 175, what the government.
You were still asking for 250 guests in August of 2020, correct?
I think I said something to that effect, but I just wanted as much as we could under the governor's orders.
And you never evaluated whether or not the 250 until August was safe, did you?
I'm sorry, I'm a little confused by your question.
Ms. Knox, you just admitted that you were still asking for 250 guests until August. I'm asking you if you ever evaluated whether this number was safe or not.
Well, if the governor told me it wasn't safe, then it's not.
You are not a public health expert, are you?
I am not.
Or a scientist?
No.
You have no education in COVID-19, do you?
I do not.
Or pandemics, for a matter of fact, correct?
Nope.
And your tour of the Nixon Lodge was over Zoom, correct?
Yes, it was.
So you have never even been to the Nixon Lodge in person, have you?
I guess I haven't, no.
And the Nixon Lodge was still offering you 75 guests, correct?
Yes, that's what they restricted us to.
And 75 was enough to cover all of Peyton's former hockey teammates, correct?
I mean, I don't know the exact numbers, but I mean, it was barely enough for family and friends.
Ms. Knox, barely enough is still enough, correct?
Yes, it is.
And the Nixon Lodge had enough to cover all of your immediate family as well, correct?
Yes.
Oh, Ms. Knox, I have no further questions, Your Honor.
Okay. Any questions from the redirect?
No redirect, Your Honor.
All right, Ms. Knox, you can step down. Thank you. And the plaintiff may call its next witness.
Yes, Your Honor. At this time, the plaintiff calls Peyton Knox to the stand.
All right, you may proceed.
Please introduce yourself to the members of the jury.
Good afternoon, everybody. I'm Peyton Knox.
What do you do for a living, Mr. Knox?
I'm a hockey player for the U.S. Olympic team. It's been my dream since I was a little boy, and well, I'm just really grateful to be here.
And what brings you here today?
My wedding, actually, with the love of my life and the most beautiful woman in the world, Parker Stevenson.
How long have you known Miss Stevenson?
We met 5 years ago on the 4th of July. People are going to say I'm naive, but I knew she was the one for me right away.
Let's talk more about your wedding. When was it going to be?
So I actually wanted to have it on the 4th of July because, that's the day that we met. You probably already think I'm a romantic, but that's just me.
And where were you guys going to have your wedding?
We actually worked with Riley, our wedding planner, and she helped us pick the Nixon Lodge.
After you decided on the Nixon Lodge, what was your next step?
We'd signed a contract with them.
Would you recognize a copy of that contract?
Yeah, you betcha.
Please direct your attention to Exhibit 2 as found on page 50 of the case materials. Let me know when you get there.
Yeah, sure. Give me a second.
Of course, Mr. Knox.
I'm there.
Can you confirm that this is the contract you signed with the Nixon Lodge?
Yeah, this is the contract we signed with them for our wedding.
Let's talk more about the promises that the Nixon Lodge made in this contract. How many guests were they going to accommodate?
We were going to have 250 people at our wedding.
And where at the Nixon Lodge were you guys going to have your wedding?
So the ceremony was actually going to be in the rose garden outside, but we had a couple indoor spaces that we could use too. Like there was going to be this big fancy suite that Parker and I could get ready in. And then our guests also had access to this cocktail bar. It was like this all-in-one package, you know, and I was pretty happy about that.
And what foods were you going to have at your wedding?
The lodge's caterer, Bobby, helped us out a lot with the food. Our families love to support small businesses and local businesses because, you know, that's our history and our heritage. And Bobby actually had a lot of connections in the area. So she actually helped us find some local fishermen and tradesmen. Like we were going to have this fresh caught Minnesota walleye and this wild rice. I was really excited about it.
When you signed the contract, did you make any payments?
Yeah, we did. We paid their entire booking fee, their entire venue rental fee, and then half of our catering fee as a down payment. It came out to like $70,000.
So, Mr. Knox, how was your wedding?
As much as I wish I could tell you that, you know, it happened and we all had a great time, it didn't end up happening.
Oh, was that because of COVID-19?
No, actually. You know, when COVID hit, we were worried, but we wanted to work with the governor's restrictions and keep people safe. But the Nixon Lodge just kept coming up with other ideas.
Well, you mentioned
Objection,
you
Your
wanted
Honor.
to.
Lack of personal knowledge. May I explain?
Sure.
Your Honor, this witness testified that that they didn't have the wedding and it was not because of COVID-19. They do not have the personal knowledge to testify as to what the Nixon Lodge made these restrictions for. This is completely inappropriate.
Okay. Any response, Mr. Law?
Your Honor, Mr. Knox is not alleging that the wedding didn't happen because of whether or not the Nixon Lodge's restrictions were because of COVID-19. He's saying that he canceled his wedding because of the Nixon Lodge's changes, not that he canceled his wedding because of COVID-19. Therefore, Mr. Knox has personal knowledge of why he canceled, and he can testify to that fact.
Anything else on behalf of the defense?
Your Honor, I apologize. I was confused by the way that the question and answer was worded. I understand. I would be happy to withdraw my objection.
Okay, very well. You may proceed, Mr. Long.
Yes, Your Honor. Mr. Knox, you mentioned you wanted to work with the restrictions put forth because of COVID-19. How did COVID-19 first impact your wedding?
Well, I mean, when COVID first hit in March, it was kind of really scary and confusing, you know, because we had folks coming in from all over the country, my hockey buddies, and then we had our grandparents flying in from France. And we wanted to have our wedding, but we also wanted to keep everybody safe, and that was a really confusing balance for a little bit.
Did you reach out to the Nixon Lodge with those concerns?
Yeah, I sent him an email in June, but that was after just months of waiting for them to call or email or text or anything, but it was complete radio silence all through March, April, and May.
Well, when you emailed them in June, did the Nixon Lodge respond?
Yeah, Chris sent over a list of all the extra restrictions that our wedding was going to have.
Would you recognize a copy of that email?
Yeah, I would.
Please direct your attention to Exhibit 5B as found on page 69 of the case materials. Let me know when you're there.
I'm there.
Can you confirm that this is the email you sent, that Chris Nixon sent to you after COVID-19 hit?
Yeah, this is Chris's reply to my email asking about our wedding.
Does it appear to be a fair and accurate copy?
Yeah, it does.
Has it been changed or altered in any way?
No, I don't think so.
Your Honor, at this time, the plaintiff offers Exhibit 5B into evidence, the authenticity of which has been stipulated.
Ms. Gort, any objections to 5B?
Yes, Your Honor, I object under Rule 408. May I explain?
Yes.
Your Honor, the case law presented within the case materials is very clear. Buckmaster establishes 3 prongs for an exhibit to be an offer to compromise under Rule 408. The first prong is that it is either an offer or conduct during a negotiation. Your Honor, Chris Nixon emailing this was starting in a negotiation, and therefore these statements are conduct during a negotiation. The first element has been satisfied. The second prong is that it is being used to show liability or a prior inconsistent statement. My opposing counsel is clearly using this to show liability, as they're using this to show that the Nixon Lodge was not being reasonable. This is exactly the liability of today's case. The second element is satisfied. The third prong is that there is not an acceptable use under Rule 408B. Your Honor, my opposing counsel has failed to lay any foundation as to how this would be an acceptable use under Rule 408B. This is an offer to compromise according to Buckmaster, and that court case is binding in today's court, Your Honor.
Mr. Long, any response?
Your Honor, while this email is a negotiation presented in the process of wedding planning, we are not using this offer to compromise as an admission of liability under Rule 408. Rather, we are using this email to show that the changes imposed on the wedding by the Nixon Lodge were, in fact, breaches of contract in and of themselves. Therefore, we are not using any offers to compromise as an admission of liability, but rather that the changes to the wedding were themselves breaches of contract under Rule 408.
So, Ms. Gort, understanding that the plaintiff is saying it's not an admission, but rather evidence of a breach?
Yes,
Your response.
Yes, Your Honor. Buckmaster still rules that any evidence being used to show prior inconsistent statements is inadmissible under Rule 408. That is exactly what my opposing counsel stated he is going to use this for. This is inadmissible.
Mr. Long, anything else?
Your Honor, we are not using this to show a prior inconsistent statement, but rather that the Nixon Lodge imposed changes on the wedding of Peyton Knox and Parker Stevenson. Therefore, it is not an admission of liability, but rather a breach of contract in and of itself, which is admissible under Rule 408B.
Okay. I'm going to overrule the objection, and the question may be asked and answered.
Mr. Knox, can you confirm that this is the email that Ms. Nixon sent to you?
Yeah, this is the email Chris replied to my email asking about our wedding.
Your Honor, at this time, the plaintiff offers Exhibit 5B into evidence, the authenticity of which has been stipulated.
Ms. Gordon, is there any other objection to this exhibit?
No, Your Honor.
Okay, it is received.
Mr. Knox, what's included in this email?
Well, Chris talks about all those restrictions that she was putting on our wedding. And then, oh, yeah, she attached a copy of the Nixon Lodge COVID guidelines and then the government COVID guidelines too.
Would you recognize copies of those COVID guidelines?
Yeah, definitely.
Please direct your attention to Exhibit 3 as found on page 59 of the case materials. Let me know when you get there.
You say 59?
59, yes, Mr. Knox.
Yes, I'm there.
Can you confirm that these are those COVID-19 guidelines?
Yeah, this is the Nixon Lodge's COVID guidelines and then the Minnesota Department of Health rules.
Do they appear to be fair and accurate copies?
Yes, they do.
Have they been changed or altered in any way?
No, they haven't.
Your Honor, at this time, the plaintiff offers Exhibit 3 into evidence, the authenticity of which has been stipulated.
Any objection to Exhibit 3?
None, Your Honor.
All right, it's received.
Mr. Knox, I'd like to briefly go back to the email you were talking about earlier. You mentioned that the Nixon Lodge made some changes to your wedding. What changes did they make?
Well, for starters, Chris said that all weddings had to be outdoors. That was kind of a bummer because Parker and I were really looking forward to using that big fancy suite. And, I'm sure our guests would enjoy the cocktails too, but Chris said no.
Was this restriction in the Minnesota Department of Health COVID-19 guidelines?
No, it wasn't in the government rules, but, we just figured that it was a way for them to accommodate more guests.
So how many guests did they offer to accommodate?
They said that we can only have 75 people at the wedding. I was really confused by that.
Why were you confused?
See, we were promised 250 guests, but of course, that's really risky with COVID and totally unsafe. So we wanted to go with the 175 number the governor recommended. But Chris just kept restricting it to 75, and I wasn't sure why.
Did the Nixon Lodge mention any other changes that they were making to your wedding?
Yeah, they just flat out canceled all the food we paid for.
Was this restriction in the Minnesota Department of Health COVID-19 guidelines?
No, it wasn't in the COVID rules or their own preparedness plan. We could have legally had our wedding with food, but they wouldn't budge.
So after the Nixon Lodge canceled your food, what did you do?
The final food payment for the wedding, the money that we owed, was due a couple days later on the 4th of June, but Chris just canceled all of our food, so I didn't pay that.
Mr. Knox, I'd like to talk more about what happened after these changes were made to your wedding. Did the Nixon Lodge ever offer you any alternatives?
No, they didn't. In fact, Riley, actually, I'm so glad we hired her. She's the one who actually asked about rescheduling the wedding. And then they said that we'd have to pay a $3,750 fee to do even that.
Mr. Knox, was this fee in the contract you signed?
No, the fee wasn't anywhere in the contract. I read through the whole thing.
Objection, Your Honor, unfair extrapolation.
Well, how do you believe it's an unfair extrapolation?
Your Honor, this witness testified that the fee is nowhere within the document. However, the fee is specifically referenced within the document. This is completely an unfair extrapolation.
Okay, I'm going to overrule that. You can cross-examine the witness if you wish on that issue. You may continue, Mr. Muller.
Yes, Your Honor. Mr. Knox, after this fee was imposed, what did you do?
Well, I talked it over with Parker, and when we heard about the fee, we decided to just cancel the wedding. But when we tried to do that, the lodge said that everything we paid them up until that point was non-refundable. I was floored.
So what did you do then?
I did what anyone would do. I threatened to sue if they wouldn't refund my money.
And how did the Nixon Lodge respond?
They said that they'd offer us a partial refund in response for not suing, but that wouldn't include the money we paid for the venue or the money we put
Objection,
down
Your
for
Honor,
our
offer
food.
to compromise.
Mr. Long?
Your Honor, in the contract that Mr. Knox signed, it includes a clause that states in the case of Nixon's breach of this agreement, they are required to pay refunds to the client. That would be on the bottom of page 52 for your reference. This clause shows that we are not using this statement by Mr. Knox that the Nixon Lodge offered a roughly $4,000 refund to prove that this offer of a refund was an admission of liability, but rather that the small size of the refund itself was in fact a breach of contract under the cancellation clause on the bottom of page 52. Therefore, under Rule 408B, this is an admissionable use of offers to compromise under Rule 408B.
Okay, Ms. Gort, any response?
Your Honor, first of all, I'd like to address that proffering isn't allowed within Minnesota mock trial high school competitions. However, my opposing counsel is completely assuming facts that are not in evidence by stating that the Nixon Lodge breached the agreement. That is exactly what we are here in court today. They cannot assume this and assume that this is not being used to show liability because of those facts. This is clearly being used to show liability.
Okay, I'm going to overrule the objection. And you're right, this trial is about evidence, and this is evidence. I'm going to allow it.
Mr. Knox, after the Nixon Lodge offered this refund, what position were you left in?
well, they wouldn't give us most of our money back, and they wanted to keep more than $60,000 of my fiance and I's hard-earned money.
Thank you, Mr. Knox. No further questions, Your Honor.
All right. We'll switch out the timers. And Ms. Gort, as soon as your timer's up, you can go ahead and proceed with your cross. If you're speaking to us, we can't hear you. What? I mean, I don't think the time has started, but obviously stop the clock until we get this all.
Can you hear me, Your Honor?
We can hear you now, yes.
Okay.
No, it's okay. All right, we'll go ahead and get started whenever you're ready.
Yes, Your Honor. First, Mr. Knox, I'd like to talk about some of the restrictions the Nixon Lodge is placing on weddings. The Nixon Lodge placed a limit on dancing at weddings, correct?
Yeah, I'm pretty sure they said that only Parker and I could dance.
You thought this went too far, correct?
Yeah, it was a bit of a step too far, but I mean, I was really more concerned about not having all my friends there.
You thought this would impact the enjoyment of your wedding, didn't you?
Yeah, I mean, I like to dance myself, but not having everybody do it with was a bit of a bummer.
Let me direct your attention to the signed contract, page 53, under 5, limitation of liability. Let me know when you get there.
Sure. Say page 53?
Yes, under 5, limitation of liability.
Yes, I'm there.
I will specifically be referring to the 4th sentence in that paragraph, starting with the Nixon Lodge shall not. Let me know when you get there.
Yeah, I think I'm there.
This section says that the Nixon Lodge shall not be liable for any claims of loss of enjoyment, doesn't it?
Oh, sure. Yeah, it does say that.
And if you flip to the following page, you signed this agreement, didn't you?
I did sign the contract, yeah.
Right above your signature, it says that you read all the terms and conditions.
I did read all the terms and conditions, yes.
And that you are bound by all the terms and conditions.
Absolutely, yeah. That's what contracts are about.
Let me direct your attention to another term and condition you agreed to. Let me direct your attention to section 4 on page 53 called transfer of service. Let me know when you get there.
Yeah, I'm there.
This section is about when a client requests a date change, correct?
Yeah, it is.
And you asked for a date change, correct?
Yeah, because of COVID.
The contract says that the Nixon Lodge will comply with date change requests based on availability, right?
Yeah, based on availability within 1 year.
And the Nixon Lodge offered you 2 new dates, correct?
They did, yeah.
So the Nixon Lodge followed this part of the agreement, didn't they?
I mean, they did charge us a $4,000 fee, but yeah, sure.
Doesn't the section specifically state that the fee is subject to change?
It does, yeah, but I don't see the words rescheduling fee. That's why I wasn't sure.
Let me direct your attention to page 55 under 1 compensation. Please let me know when you get there.
55 compensation. Oh, yes, I'm there.
Let's start with part A. This part of the agreement required you to pay a deposit to the Nixon Lodge, correct?
Yeah, we paid that.
And it says the deposit is non-refundable, right?
Non-refundable deposit. Yeah, it does.
The contract describes what this deposit is for, doesn't it?
It does.
It says the deposit is for reserving the event date, doesn't it?
Yeah, it does.
And the Nixon Lodge did reserve July 4th, 2020 for your wedding, didn't they?
They did, yeah.
Let me direct your attention to part B. This part of the agreement required you pay the balance due to the Nixon Lodge 30 days prior to the event, correct?
Yeah, for sure, but I'm pretty sure this entire section is about catering.
Thank you for that elaboration. I was not asking you anything further about that. It says the payment is to secure the event date, correct?
Wait, which section are you talking about again?
Part B,
A or B?
it says that
B.
the payment is in order to secure the event date.
Days prior to the event. Yes, you're right.
And 30 days prior to July 4th is June 4th, correct?
Yeah, that's right.
And you did not make a payment on June 4th, did you?
No, I didn't. That was the remainder of our food payment, and Chris canceled all the food.
But doesn't the contract say that this fee is for reserving the event date?
Yeah, it also says that they have to give us food.
Now, you did not follow this section of the agreement, did you?
No, I didn't. I didn't pay for things that were canceled.
Let me direct your attention to the cancellation section of the agreement on page, I believe that is page 52 and 53. Let me know when you get there.
Yes, I'm there.
The first sentence on page 53 says that the Nixon Lodge may withdraw services if the client does not pay the Nixon Lodge's fees by the scheduled dates outlined in the contract.
It does, yeah. And then a little bit earlier, it says that we can get a refund if they break the agreement.
Thank you for that elaboration, but that was not my question. The first sentence says that the Nixon Lodge may withdraw services if the client does not pay the fee scheduled by the outlined dates, correct?
On the first sentence of page 53, yes.
And a cancellation can also occur when a client provides written notice.
Yeah, that's what it says.
And didn't you provide the Nixon Lodge with written notice that you were canceling?
When exactly are you talking about?
I'm referring to an email that you sent to the Nixon Lodge.
Sure, yeah, we send lots of emails. I'm just asking which one specifically.
I believe it is 5M.
5M, all right. What page is that on?
If you could give me a moment, Mr.
Of course,
Knox.
Absolutely.
On page 80.
Page 80, sure. Oh, yes, I'm there.
So you did provide the Nixon Lodge with written notice that you were canceling?
Yeah, in September, after they canceled all of our food and all that shit.
And the agreement states that any payments made prior to the cancellation will be retained by the Nixon, correct?
Where exactly does it say that?
In the cancellation section that I was referring to.
Yeah, I think you're right. Yeah, but again, if they break the contract, it says that we get a refund.
Thank you, Mr. Knox. I have no further questions, Your Honor.
All right. Any follow-up from Mr. Long based on the cross-examination?
No redirect, Your Honor.
Okay. You can step down, Mr. Knox. And is the defense ready with its first witness?
Yes, Your Honor. The defense would like to call Tony Olivia to the stand.
Okay. Whenever you're ready, you may proceed.
Please state your name for the court, spelling the last.
Hi, my name is Tony Olivia, Olivia.
What do you do for a living?
I am the lead venue planner at the Nixon Lodge.
How long have you had this position?
I've been working at the lodge for quite some time now. I think I started as a venue planner in 2010, and I was promoted to lead venue planner in 2017.
What are your responsibilities as lead venue planner?
Some of my main responsibilities include working with the wedding party, coordinating with vendors, creating the floor plan, and overseeing the wedding in general.
Has COVID-19 impacted operations at Nixon Lodge?
Oh yeah, just like any other business, we were forced to shut down in March of 2020 due to the governor's executive order. But we were able to reopen in June with some restrictions.
What were these restrictions?
One of the main things that we had to consider was the amount of people we could safely accommodate at the lodge, given the pandemic.
How did you come to your decision?
There were three main things that we evaluated. The first was the Department of Health guidelines.
Your Honor, permission to show the witness what has previously been entered as Exhibit 3?
Certainly.
Now, Mr. Olivia, do you have that document in front of you?
Yes.
Can you summarize how these rules impacted the Nixon Lodge?
The government was recommending that we do not open up to host large gatherings at all. If we were to open up to host any sort of gathering, we needed to make sure that we could do so safely and that we were following all of the government restrictions.
What do you mean?
The government gave us 10 items to evaluate. 8 were not an issue for the lodge, but 2 required much more time and consideration.
What was the first item?
The first was airflow. We had to evaluate the airflow at the lodge to see how we could safely accommodate all of our guests and staff.
What did you consider as part of this evaluation?
Well, the building itself is over 100 years old. It's had some refurbishments over the decades, but the ventilation system has never had any serious upgrade.
How did this impact the number of people that the Nixon Lodge could accommodate?
Because of the ventilation system, we made the difficult decision to limit the amount of people to 75 for as long as the pandemic restrictions remained in place.
Respectfully, Mr. Olivia, I'm not really sure I understand the logic there. Why would an indoor ventilation system impact an outdoor wedding?
Honestly, I was confused at first too. But after 3 months of planning and developing our rules, we realized that in case of a weather-related incident, our contract required us to be able to move the wedding indoors, and we had to be able to do so safely.
Let me direct your attention back to the government restrictions. What was the second item that you needed to evaluate?
The second was 6 feet of social distancing. We, as the lead venue planner, I had to evaluate the floor plan and see how we could safely accommodate all of our guests and staff.
Let me direct your attention to the venue pre-COVID. How would you normally set up the space for a wedding?
Normally we have about 70-ish tables that we can work with. We can arrange them many different ways to create a variety of patterns.
How many guests could each table accommodate?
Each table could hold up to 10 guests.
And approximately how much space was between each table?
Each table only needed to be a few feet apart to allow the safe passage of all of our staff and guests.
How did COVID-19 impact this setup?
Now the tables need to be even more spaced apart. We had to make sure that we were following the 6 feet of social distancing rule.
What about the number of guests at each table?
We are now limited to 4 people per table. 6 if they are all from the same household.
At this point, Mr. Olivia, we've talked a lot about what restrictions were in place, but I want to ask why. Why did the Nixon Lodge impose these restrictions on the number of guests?
We chose this number 75 for the safety of all of our guests and staff at the Nixon Lodge.
Thank you, Mr. Olivia. I have no further questions, Your Honor.
Thank you. Does the defense have any questions? Or the plaintiff, I'm sorry.
Yes, Your Honor.
Okay, you may go ahead and proceed.
Good afternoon, Mr. Olivia. Today I'd like to talk to you about capacity. The original contract was for 250 people to attend.
That was what we had originally planned, yes.
And Department of Health regulations required that this capacity be lowered to 175 people.
Actually, the Department of Health recommended that we do not open up at all. They were recommending 0 people at events. The maximum was 175.
But you lowered this maximum to 75 people?
We didn't lower the maximum. We put our maximum in the range between the recommended 0 and the maximum of 175.
But this new maximum was 75 people?
Yes, that is correct.
And on your direct examination, you stated that this was due to Nixon Lodge's ventilation system.
That is correct.
But you also stated that your outdoor space had no ventilation issues.
Well, our outdoor space wouldn't have any ventilation issues. It is outside.
And the wedding was scheduled outside.
Yes, however, our contract required us to limit the impact of weather-related events as much as possible, so we had to be prepared to be able to move the wedding indoors.
Well, in that case, I'd like to discuss your ventilation in some more detail. Nixon Lodge's ventilation has never been upgraded?
It has never had any serious upgrade, no.
Nixon Lodge did not upgrade its ventilation when the pandemic hit.
Well, no. Our building is a historic building. We are a business. It's one of our main selling points. If we were to upgrade the ventilation, we could destroy the historical value of the building.
Mr. Olivia, Nixon Lodge closed down in March.
That is correct.
Nixon Lodge remained closed until June.
Yes.
So in all this time, Nixon Lodge did not take any action to fix their outdated ventilation system?
Well, no, like I just said, the historical feeling of our building is one of our main selling points as a business. If we were to upgrade the ventilation system, we could ruin it.
You prioritize the historical value of your building over the safety of your guests?
Well, we were still in the limit of the government. There was no reason for us to upgrade it.
So you still claim that the 75-person limit was necessary?
Yes, in case of a weather-related incident.
But you yourself offered to break this limit.
No, I'm sorry. What are you talking about?
I'll clarify. Please turn to Exhibit 5J located on page 77 of the case materials.
Give me a second while I bring it up. I have it here.
This is an email that you sent to Mrs. Jordan Knox.
Sorry, I'm not familiar with it. Just give me a second to read through it.
Of course, Mr. Olivia.
No, I didn't write this email. This looks like a forged document.
Mr. Olivia, is it your testimony that Exhibit 5J is not a fair and accurate copy?
Yes.
You Mr. Olivia, you're testifying that a forged exhibit was entered. Mr. Olivia, you're testifying that a forged email was sent from your account?
Well, this isn't even my email. I didn't send this email.
This states that it is sent from TonyOlivia@NixonVenue.com. Is that correct?
This says T Olivia. That's not my email.
So you did not send this email?
No, I did not.
So you never offered to hold more than 75 guests?
No, we were going to go with what was in a preparedness plan.
Thank you, Mr. Olivia. No further questions.
All right. Ms. Gord, any redirect?
Yes, Your Honor. Mr. Olivia, on cross-examination, my opposing counsel asked you a lot about an email that they claimed you sent. Do you have any evidence that this isn't your email?
Yes, I see quite a few discrepancies in here. First, this is set at almost 11 p.m. at night. I would never do something as unprofessional as that. Secondly, this is sent to the parent of our clients, not our actual clients. If I would like to talk about the wedding, I would always go to the clients that we are working with. Third, this is signed venue planner. I would always sign my emails as lead venue planner. And lastly, this is at a zip code of 55746. The Nixon Lodge's zip code is 55747. I did not write this email.
Thank you, Mr. Olivia. I have no further questions, Your Honor.
Right. Thank you. Anything else from the plaintiff?
Nothing further, Your Honor.
All right. Thank you. You may step down, sir. And the defense may call its next witness.
Yes, Your Honor. The defense would like to call Bobby Stewart to the stand.
All
May I
right. You may.
Please state your name for the record, spelling the last.
Bobby Stewart, Stuart.
Where do you currently reside?
I've lived in Hibbing my entire life.
And what do you do for a living?
I'm the catering manager for Nixon Lodge and Catering.
What experience do you have for this position?
Oh, I've always been a foodie. Seafood, Brussels sprouts, you name it, I love it. My parents were the same way. I guess the Honeycrisp doesn't fall far from the tree.
What's your educational background?
I attended a local community college to earn a business degree so that I could cater, literally, to the finer taste of those in our community. You know, food is such an important part of each event, so making it a unique experience for everyone became my goal.
How did you become employed with the Nixon Lodge?
I met Chris Nixon right after I graduated. The lodge was looking for a banquet manager, and I saw an opportunity to pitch my vision.
What was your vision?
My idea was to find at least one special item for each wedding just to make things unique. Something like a food or a drink that meant something to the couple.
Now, Ms. Stewart, what exactly does a banquet manager do?
There are a lot of moving parts in running a banquet service. On the front end, we work with the venue, the wedding clients, and often their wedding planner to draw up a banquet event order, or BEO for short.
What is a BEO?
The BEO includes all the important details for the event. So things like table linens and napkins, chair coverings, food and drink options, that sort of thing.
How are the items on a BEO decided?
We have different baseline packages for food service. The client decides which package they want, and then we discuss, my favorite part, their unique food or drink item.
What happens after a BEO is completed?
The final expected cost based on food, beverage, labor, and overhead is calculated. And then I factor out a down payment, which is usually 50%, plus 100% for special order items.
What happens after a BEO is signed?
I meet with the clients for a final food tasting and then begin work on the ordering.
Let me direct your attention to the case at hand. Were you involved with the wedding of Parker Stevenson and Peyton Knox?
Yes, I was in charge of the catering for their wedding.
When did you first meet the couple?
I met them back in June of 2019.
What did you discuss when you met the couple?
We spoke about their background and history together. As I mentioned before, I try to find a food or drink that meant something to the couple.
Did you find one?
Yes. I had learned that their family had moved to America from southern France. And then it hit me. Black truffles. I could practically taste the fresh black truffle tapenade at each table and the fresh shaped truffles on all of the appetizers.
How did the couple respond?
They loved the idea.
Now, Ms. Stewart, how expensive are black truffles?
French black truffles are not cheap, especially fresh Perigord truffles that can sell for an upwards of $1,500 per pound.
Were any other items decided upon for the BEO?
In addition to the truffles, the couple chose our high-end gold wedding package. The full details of what this package included are listed on the contract addendum in the BEO that the couple signed.
Your Honor, at this point, permission for the witness to use an enlarged version of Exhibit 2 and mark the exhibit as both parties have already agreed upon in Stipulation 1.
Okay. Any objection from the planner?
No objection, Your Honor.
Okay, you may do so.
Let me direct your attention to the deposit. What deposit was required?
A deposit of 50% of the total estimated cost was due at the time this agreement was signed. In this case, the total estimated cost was a little over $36,000, making the 50% deposit approximately $18,000.
Is this deposit refundable?
No, the contract specifically states that this deposit is non-refundable.
Let the record reflect that Ms. Stewart has circled the word non-refundable on the contract.
It will.
Ms. Stewart, what was this deposit for?
The contract says that this deposit was for securing the date of the event.
Let the record reflect that Ms. Stewart has circled the phrase secure the date of the event on the contract.
She has.
Thank you, Ms. Stewart. You can put down the exhibit now. Was final approval given by the couple?
Yes, final approval was given on December 3rd, 2019.
What did you do after final approval was given?
I began work on procuring these special items, in this case, the black truffles.
When did you begin ordering these truffles?
I began working in late March, early April, about 90 days or so before the wedding.
What work did you do?
I was able to find a small boutique distributor out of Maryland that specializes in wild mushrooms. Through them, I ordered 6 pounds of fresh black truffles from a farm in Champignon, southern France.
When did you need to pay for these truffles?
Because the distributor and farm were small businesses, I had to pay for the items up front.
How much did you pay?
I paid $8,000 for the products themselves, plus another $1,000 in labor costs involved with the ordering and storing of the products.
When did these truffles arrive?
The truffles arrived on June 12, 2020. I stored them in their own temperature-controlled unit to ensure that they would be fresh for the wedding.
What happened after that?
Long story short, the wedding was canceled by the couple.
Your Honor, at this point, permission for the witness to use an enlarged version of Exhibit 2 again.
Certainly.
What happens to a deposit when a wedding is canceled?
Our contract is quite clear. When a client cancels their wedding, any payments made prior to the cancellation will be retained by Nixon Lodge and considered proper compensation for reserving the event date.
Thank you, Ms. Stewart. You can put down the exhibit now. So what did this mean for the food that the Nixon Lodge had already ordered?
Well, we were sitting with 6 pounds of frozen truffles that no longer belonged to the couple.
So what did you do?
Unfortunately, black truffles can grow a bacteria that can make people sick since they are a potentially hazardous food. There really wasn't anything we could do but dispose of them. Luckily, I managed to take about 1 pound home though. The foodie and me just couldn't let them all go to waste.
Ms. Stewart, you testified earlier that the deposit was for reserving the date of the event. Did Nixon Lodge and Catering reserve the date of the event for the Knox-Stevenson wedding?
Yes, this whole COVID situation is obviously terrible and I feel so badly for the couple. But the funds they paid were for reserving the date, and we did reserve the date.
Thank you, Ms. Stewart. I have no further questions, Your Honor.
Thank you. Long, when your timer is available, you can go ahead with your cross. You may proceed.
Yes, Your Honor. Good evening, Ms. Stewart. Good afternoon, Ms. Stewart. I'd like to ask you a few questions about catering. Now, as you mentioned on direct examination, you signed a catering contract with the Knoxes, is that right?
Yes, that is correct.
And according to this contract, you were obligated to provide a number of things for the wedding.
As was the couple obligated to provide the money for them, I was obligated to provide the catering. It's my job.
Of course, Ms. Stewart. Now, in this contract, you were obligated to provide service for the wedding.
That was a part of it, yes.
And you were also obligated to provide truffles for the wedding.
No, I wouldn't say necessarily obligated, but since the truffles were a luxury item, but it was a part of our contract as so long the couple paid for them.
And you were also obligated to provide the rest of the food to the couple. Is that right?
Again, I wouldn't necessarily say obligated. It was just a part of the contract.
Well, you claim you abided by this contract. Is that right?
I did. I was fully prepared to cater the food and the truffles and provide service. Unfortunately, we did have to cancel it for their July 4th wedding as per the government restrictions. It just wasn't safe to do so. But we were prepared to provide all of that for their October 23rd date, COVID allowing.
Well, let's talk more about that October 23rd date. After the wedding was rescheduled, your boss approached you about finding more workers for the wedding. Is that right?
Yes, that is true. She did.
And at this time, she was hoping that you could find more workers to accommodate more guests for the Knoxes.
That is true. However, I had to turn down this offer as I could not find the help that we were hoping for, as many of my employees were just uncomfortable with serving such a large wedding during a pandemic.
And you didn't push very hard to find this help, did you, Ms. Stewart?
I was not about to put my employees into a situation where they felt uncomfortable and unsafe. So I was not going to push them into doing that.
Well, let's talk about the truffles now. Now, in the contract, Mr. Knox paid $8,000 for truffles.
No, that's wrong. Any money and funds that the couple paid went to reserving the event date, not truffles.
Mr. Stewart, Miss Stewart, is that your testimony that that $8,000 did not go for the truffles?
Yes, I believe you might be getting a bit confused. As I remember, I did say that we had used the deposit to provide things like service and food. However, in the contract, it specifically states that all money and funds were for reserving the event date. Yeah.
So, Ms. Stewart, I assume, as you said on direct examination, you've read this contract.
Correct. I signed and had to know every bit of it, and I do.
And you also prepared an affidavit for today's trial, is that right?
Yes, I did.
Now, you'd agree that it's important that you state exactly what these payments are for in your affidavit.
Yes, however, in the contract, as I've said, it's for all funds were for reserving the event date. In my affidavit, I said that we use the deposit to purchase things like food, service, and at one special item. That is what the deposit is for. That's why we have one. But all money went for that deposit was to reserve the event date.
So you admit that there is a discrepancy between your affidavit and what the contract actually says.
Objection, Your Honor. Relevance.
Okay, I'm going to overrule the objection. It's relevant. Mr. Long, you can continue.
So, Ms. Stewart, to be clear, you do admit that there's a discrepancy between the contract and what your affidavit says.
No, nothing I said was wrong.
Well, as you said, you prepared a copy of your affidavit for today's trial. Please direct your attention to your affidavit.
Give me
as
1
found
second, I have to pull it up.
Of course, Ms. Stewart. It's on page 35 when you need it.
Yes, here it is. I have it. Now you may continue.
Now, you'd agree that this is your affidavit.
Yes, this is my affidavit. However, I do believe you're getting, as I said, that one statement confused. I said that we use the deposit to purchase things like food, service, and that one special item. But in the contract, it clearly states that that money they paid is for reserving the event date. Those are two different things. Or not necessarily different, but they are
Miss Stewart,
the contrary.
This is your affidavit and you signed it on page 37.
Yes, I did.
Please direct your attention to lines 34 and 35 of your affidavit. Please read silently as I read aloud.
Objection, Your Honor. Improper impeachment. May I explain?
Yes.
In order to impeach Ms. Stewart, she would have had to said an inconsistent statement in her testimony. My witness has clearly said that the contract says that the deposit is for reserving the event date. We've proven that to be correct. Exhibit 2 has already shown that this information is consistent. Therefore, to impeach her on this statement is improper.
Okay, Mr. Long.
Your Honor, there is no consistency between Ms. Stewart's affidavit and the actual contract. Therefore, an impeachment would be proper to highlight this contradiction.
Okay, Ms. Congdon, anything else?
Yes, Your Honor. The contract very specifically says that the money is the deposit is for reserving the date of the event. And Ms. Stewart's testimony says that she uses deposit, however, the Knox was pleased. This money was going to be used this way, and that was already stipulated. That's not an inconsistent statement on whether she uses the deposit for food or not, as the contract already says that the money is for reserving the date of the event. What she uses that money for is not inconsistent.
When you say that it was already stipulated, what stipulation are you referring to?
My apologies, Your Honor. I think I just misvocabbed that.
Okay. Mr. Long, anything else?
Your Honor, I'd just say that impeachments are to highlight contradictions, not to necessarily show what is true.
I agree with Mr. Long. I'm going to overrule the objection. The witness will be directed to answer the question.
Now, Ms. Stewart, please direct your attention to lines 111 through 112. Please read silently as I read aloud. They agreed to put that money down so I could ensure their wedding had food, service, and that one special item. Did I read that correctly?
While you have read that correctly, I believe I might have just not have explained this clearly. The contract specifically states that all funds are for reserving the event date. What we use the deposit for is what that is for reserving the event date. That means that in my statement, when I said this, I was just saying to prove that I upheld my part of the bargain. We had purchased the food for reserving their event date.
Okay, Ms. Stewart. Let's talk about the rest of the food that you promised to the Knoxes. You typically order the food about a week before a wedding event. Is that right?
Pre-COVID, absolutely. However, now with COVID, we were unable to ensure that we would get food on time with only 1 week ahead.
So is it your testimony here today that you ordered the food at a different time than 1 week ahead from the wedding?
I had to. I mean, this was during a time when we were unsure whether or not if items would arrive on time due to COVID. So we did start to order products early to ensure that we could have them for the wedding as we had promised in our contract.
Now, Ms. Stewart, you have a copy of your affidavit in front of you, right?
Yes, I still have it.
And you've already stipulated that this affidavit is true and correct to the best of your knowledge.
Yes, it is.
Now, Ms. Stewart, please direct your attention to lines 38 through 39 of your affidavit. Please read silently as I read aloud. I generally order food and drink about a week before. Did I read that correctly?
Objection, Your Honor, improper impeachment.
What do you think is improper about it?
Yes, Your Honor, my witness has already testified that that is generally what she does. This is not inconsistent. What she did for this wedding was due to the COVID pandemic, and that is what the force majeure is here to disclose. Now, saying that she is inconsistent just because she didn't follow this section is not a proper impeachment, as she already admitted that this is generally what they would do. She hasn't said anything inconsistent to that.
Your Honor, may I be heard?
Yes.
This is only one part of the impeachment process of Ms. Stewart. Here she says that she typically orders the food about a week before. And as this impeachment continues, it will be revealed that nowhere in this affidavit does she say that she did otherwise for this wedding. Therefore, it can be reasonably inferred from her affidavit that she did nothing different than normal. Ms. Stewart had the opportunity to include the fact that she ordered the food at a different date, but she did not include that in her affidavit. Therefore, it can be reasonably assumed that a week before the wedding would have been when she ordered the food.
Anything else, Ms. Condon?
Yes, Your Honor, it's not proper to reasonably assume something from an affidavit, as we are reading this affidavit in a different way than opposing counsel is. Like I said, Ms. Stewart has already testified that this is generally what she does. To impeach her on something that she's already testified to is an improper impeachment.
Okay. I'm going to overrule that. I'm allowing the question. You may proceed.
Now, Ms. Stewart, nowhere in this affidavit do you include the fact that you ordered the food at a different time than 1 week before.
Objection, Your Honor. My apologies. I redact my.
No, I did not. However, this was generally what we were doing. I was explaining my job and what I do for the Nixon Lodge.
Okay, Ms. Stewart. Now, you're the catering manager for the Nixon Lodge, right?
Yes, that's my job.
And as the catering manager, you'd agree that it's important that you're on the same page as all of your fellow staff members.
I suppose so, yeah.
So you'd agree that you'd want to be updated if any changes to the Knox wedding were made.
Yes, however, that job did not fall upon my fellow staff. that fell upon the couple themselves. It's clear, it states in the contract that the client must provide us with any updates. It's not our job to reach out to them or for my own teammates to, not teammates, my own staff to come to me and tell me about these things.
But Ms. Stewart, if your own staff made changes to the wedding, you'd want to know.
I would be aware at that point, yes.
So if your boss were to say, cancel all of the food for the July 4th wedding, you'd want to know about that.
I did know about that. And that's exactly what we had to do because according to the government restrictions, it was unsafe for us to provide catering for their wedding.
Ms. Stewart, is it your testimony here today that you knew that this food was canceled?
I was very much aware that we had to cancel for the July 4th wedding, but we decided to reschedule the wedding to October 23rd. So I decided to save the food for that date.
So, Ms. Stewart, is that a yes that you believe that you know that the food was canceled?
I would say so.
Now, Ms. Stewart, you have a copy of your affidavit in front of you. Is that correct?
Correct.
Nowhere in this affidavit does it say that you were informed that the Nixon Lodge had canceled the food.
No.
Thank you, Ms. Stewart. No further questions, Your Honor.
Thank you. Any redirect based upon that questioning?
Yes, Your Honor, if I may.
Okay, we'll just wait for your timekeeper. All right, you may proceed.
Ms. Stewart, opposing counsel was asking you about why you ordered the food early and why it wasn't in your statement. Do you remember saying that you ordered the truffles 3 months early in your statement?
Yes, I clearly had stated that we ordered it early, about March or April.
And opposing counsel seemed to bring up that you used a deposit for in your statement. Would you like to elaborate?
The deposit was specifically for, in the contract, as it states, reserving the event date. We had used that deposit to purchase items for the wedding, as is the purpose of the deposit.
Why didn't you refund any of the down payment?
It's non-refundable. And as the contract states, non-refundable, and because the couple had canceled their wedding.
And lastly, Ms. Stewart, why did you order the food so early?
This was during COVID-19.
Objection, unfair extrapolation.
Okay, and which do you think is unfair?
Your Honor, the fact that Ms. Stewart said she ordered the food early is an unfair extrapolation. May I explain?
Sure.
Your Honor, as established on cross-examination, nowhere in Ms. Stewart's affidavit does she say that she ordered the food early. Now, the truffles are another story. We agree that Ms. Stewart did order the truffles in April. However, as for the rest of the food, we do dispute that she ordered this early, as shown on cross-examination, and nowhere in her affidavit does she say that she ordered this food early. Therefore, it would be an unfair extrapolation from the affidavit.
Ms. Congdon, do you believe that there's information in the affidavit that says that Ms. Stewart ordered it early, the non-truffle food?
Yes, I do. At the end of her affidavit, it stated that she had already ordered the food.
Could you point to the page and line?
Yes, Your Honor, if you would give me a second.
Certainly.
All right, it should be lines 112 through 114. May I read aloud?
Certainly.
They agreed to put down that money so I can ensure that their wedding had food, service, and one special item. I upheld my part of the bargain. I could not anticipate COVID-19 pandemic, and they did not cancel their wedding until after I ordered the food.
Hey, Mr. Long, your concern is that she said that she ordered it in advance, or that it was ordered months in advance, or what's your belief regarding unfair extrapolation now?
Yes, Your Honor. The defense believes, the plaintiff believes that the unfair extrapolation occurred when she said she ordered the food earlier than 1 week before the wedding. This statement only shows that she ordered the food before the wedding was canceled, even though the wedding was canceled much later in October and September, around that time frame. So this statement does not reveal or contradict the fact that she ordered the food 1 week before the wedding. Therefore, saying that she ordered the food in advance would be an unfair extrapolation from the plaintiff's perspective.
Okay. I'm going to rule that it's not an unfair extrapolation. Then you can recross if you wish on that issue.
Yes, Your Honor.
Ms. Stewart, why did you order the food so early?
This was during COVID-19. I mean, you couldn't even get toilet paper for your house at the time. Getting enough walleye and beef and to serve 250 guests at a time when grocery stores could not even keep their shelves stocked with essentials was challenging. Of course, I ordered early. I was doing everything I could to make this wedding happen as close to the agreement as possible.
Thank you, Ms. Stewart. I have no further questions, Your Honor.
All right, Mr. Long, anything else?
No recross, Your Honor.
All right, you can step down, Ms. Stewart. Thank you. And the defense may call its final witness.
Yes, Your Honor. At this time, the defense would like to call Chris Nixon to the stand.
All right, you may proceed.
Please state your name for the record, spelling the last.
Chris Nixon, Nixon.
What do you do for a living?
I'm currently the owner of Nixon Lodge and Catering, along with the sales manager.
Can you tell me a little bit more about the Nixon Lodge?
Absolutely. Back in the 1950s, my grandparents wanted to make it an event center, so they bought a building in Hibbing and called it the Nixon Lodge. The business was passed from my grandparents to my parents and then to me in 2019.
What is your educational background?
I went to college at the University of Minnesota in Minneapolis, where I graduated with a Bachelor of Arts degree in marketing.
Do you have any experience in the event industry?
Quite a bit. After I graduated from college, I got a job at Peony Estates under Harper Martini. We did everything from business conferences to weddings to parties.
When did you first begin at the Nixon Lodge?
That would be in 2016. I was hired in the sales department. 2018, I was promoted to sales manager, and on January 1st, 2019, I became the owner in addition to my sales duties.
Let me direct your attention to the case at hand. Were you involved in the wedding of Peyton Knox and Parker Stevenson?
I was. Our venue was scheduled to host their wedding July 4th, 2020.
Let's start from the beginning. When did you first come in contact with the couple?
Peyton Knox contacted me early March of 2019. We set up a tour for June 19th.
What happened during the tour?
Well, the tour went great. They loved the venue. And after the tour was over, a contract was signed for them to host their wedding at our venue.
Were you involved much after the signing of this contract?
No, not until the COVID pandemic hit.
How did the coronavirus impact the Nixon Lodge?
When COVID hit, we spent months developing a safe way to host weddings and other events at the lodge during a pandemic.
What did you do first?
One of our first steps was to consult with experts at the University of Minnesota and Hibbing's building inspector. I wanted to learn as much as I possibly could so I could create a preparedness plan.
Did the Nixon Lodge create such a plan?
Yes, we did. To create a plan, we had to evaluate three main things. We had to evaluate how many people we could safely accommodate, what those said attendees could safely do, and what safety policies we would need to implement to keep people safe.
Let's talk about those policies. What restrictions did the Nixon Lodge implement to keep people safe?
We developed many safety rules to allow for weddings to be possible. We followed all mask and social distancing rules established by the governor. We even purchased face coverings and face shields, gloves, and disinfectants, along with setting up sanitation stations throughout our entire venue to keep people safe.
Can you tell me a little bit more about these restrictions?
Definitely. Well, because of the 6 feet of social distancing, there was no way to safely serve food at any of our events. The main problems were buffets and served dinners.
What was the problem with the buffet?
A buffet would mean we had to break social distancing guidelines and people would touch the same serving items without sanitation in between uses. This goes directly against government restrictions.
And what about a served dinner?
Well, the served dinner is a problem because my staff must go from table to table, person to person. Again, this breaks social distancing and government's restrictions.
Let me direct your attention to the capacity. How did the Nixon Lodge determine a safe capacity for the lodge?
Well, we started with looking at the government restrictions themselves.
What did you determine?
The government order recommended having no guests, not even hosting events in the first place, but we wanted to find a safe number we could host.
And what number was that?
We determined that we would limit the number of guests at the lodge to 75.
Let me direct your attention to the number 175 in relation to the capacity. Where does that number fit in?
Well, that's actually the government maximum. I just want to make it clear that this is never quoted as a recommendation or even a government restriction. It's just the maximum.
Why didn't you just simply follow the maximum?
Well, that would not only be unsafe, but also illegal. The government—
Objection, Your Honor. Improper opinion as to having 175 people being unsafe. This witness does not have medical training, and therefore her testifying that 175 people would be unsafe is an improper opinion under Rule 701.
Any response?
Yes, Your Honor. This witness just testified that they met with building inspectors and health inspectors to be able to assess the ventilation system at the lodge and create a preparedness plan. Based on that preparedness plan, that immediately becomes law once it's been approved. And because that plan was approved, that is illegal to go against the preparedness plan. She does have the capability to testify on that, as not only is she familiar with the preparedness plan, she's also familiar with the people who helped write that plan.
Well, the objection wasn't about her statement that it was illegal. It was that her statement that it was unsafe, and arguing that she doesn't have the ability to provide that opinion. Do you believe that she can provide that opinion under Rule 701?
Yes, Your Honor, I do. As I just stated, she had talked with several people and they simply explained what was safe and what was not safe to the lodge. She is simply relaying that information for the court. They are not here to testify. Therefore, through her and this preparedness plan is the way we can get that information.
So you're saying it's not her opinion, it's her passing on what she heard from others?
She had a conversation, her and the other people made this decision, Your Honor.
Okay.
May I?
I'll hear from the plaintiff's counsel.
Yes, Your Honor. If the defense's argument is that she is passing on out-of-court statements to be used for the truth of the matter asserted, specifically that having 175 people was unsafe, then I would amend my objection to hearsay, as the defense has just admitted that they are offering this for the truth of the matter asserted.
Okay, Ms. Garrison, anything else?
Yes, Your Honor. We are not using the building inspector's statements. We are using Chris Nixon's statements herself. That is not hearsay by definition, as it would be opposing counsel's party opponent.
Okay, well, it's actually, you're presenting the testimony of your witness, but I want to just understand your argument that it's not opinion testimony was that she was simply passing along statements from others, and you're trying to defeat a claim that it's hearsay by saying that it's her opinion.
Your Honor, I apologize if I was unclear. She was the one who had a conversation with these other people, and together they had made this decision. This is just as much her decision as it was theirs.
Okay. Based upon the arguments of counsel and the objections made, I think it's a close call. I will allow it, and I'll allow cross-examination, obviously, by the plaintiff's counsel of Ms. Nixon if they wish to. Okay, you may proceed.
Yes, Your Honor. Ms. Nixon, let's go back. Why didn't you just simply follow the 175 capacity for the lodge?
As I was saying, it would not only be unsafe, but also illegal. Government rules require us to evaluate our specific space and come up with a venue-specific limit. That's how we determined our safe limit of 75.
Now, how did all of these restrictions impact your wedding contracts?
Well, our contracts have a section that specifically addresses these types of situations.
What section?
The force majeure section.
Your Honor, at this time, permission to show the witness what has been previously marked and entered as Exhibit 2.
Certainly.
Ms. Nixon, referring to Exhibit 2 under number 6, additional provisions, what does the force majeure section say?
No party to this agreement shall be liable in damages or have the right to terminate this agreement for any delay or default in performing. Hereunder, if such delay or default is caused by conditions beyond its control.
Ms. Nixon, did the Nixon Lodge cause the coronavirus?
Of course not.
Was the Nixon Lodge in control of the coronavirus?
Of course not.
Does the force majeure section require anything of the party claiming it?
Yes, the party claiming force majeure must make reasonable efforts to comply with the terms of the contract and performance thereof.
What efforts did the Nixon Lodge make in this case?
Well, we made efforts in 4 main ways.
Well, what was the first?
We developed safety rules to allow for weddings to be possible. We spent time and our money to ensure that we were able to have guests and comply with all of the safety restrictions.
What was the second way?
We were trying our absolute best to have this wedding as close to the contract as possible. We offered the same 4th of July date, the same gorgeous Nixon Lodge, same decoration, same music, same flowers.
What was the third way?
We followed the contract whenever possible. When they asked for a date change, we offered them multiple options, just like our agreement indicates. And we still followed almost every section of our contract: outside vendors, hours, pets, insurance, deliveries, and security.
And what was the fourth and final way?
Well, we only changed things that were absolutely necessary or required by law. This is a pandemic after all, and we only wanted to do what was safe.
Thank you for your testimony, Ms. Nixon. I have no further questions, Your Honor.
Thank you. Any questions from the plaintiff?
Yes, Your Honor. May I proceed?
Yes.
I'd like to begin by talking about the rescheduling fee that you imposed on my client. During your direct examination, you claimed that this was allowed under the contract?
It was. It says it's subject to change.
This is under the transfer of service clause, correct?
Correct.
Which says that the fee is subject to change based on the new event date?
Yes.
Let's compare the two dates. The Knox's wedding was originally scheduled for July 4th of 2020, correct?
Correct, which was originally, before the pandemic, a very popular date on a holiday. But ever since COVID hit, pushing dates later into the year have become more popular. Therefore, the October 23rd date was more, well, requested than the July 4th.
Ms. Nixon, is it your testimony today that the October date was more valuable than the July date?
July date was very valuable, but because of the pandemic, yes, the October date was more desirable to many of our clients.
Ms. Nixon, I'd like you to turn your attention to your affidavit located on page 38 of the case materials. Please tell me when you get there.
38?
That's where your affidavit starts, yes.
Oh, okay. I'm here.
Now, this is the affidavit that you wrote, correct?
Correct.
And you were aware that you had up until the day of this trial to change this affidavit?
That is correct.
Or add any relevant information?
Yes.
Now, on the last page there is your signature.
Yes.
I would like you to turn your attention to the paragraph starting on line 148. Like you to read, I'd like you to start at the third sentence of that paragraph, the rescheduling fee. Please read silently as I read aloud. The rescheduling fee was necessary because the 4th of July is a high demand date. Did I read that correctly?
Yes, you did.
Now I'd like to talk about the catering for my client's wedding. You canceled Mr. Knox's catering on June 2nd, is that correct?
Well, yes, that's when we first notified them because it would be unsafe to serve them food.
Now, this was 2 days before my client's final payment was due.
Yes.
This final payment was going to go for Mr. Knox's catering.
It was, but the contract still requires them to pay because the money still goes towards reserving the event date. So even though it was going towards catering, ultimately it went for reserving the date.
Ms. Nixon, this payment was dependent on the food, not the date, correct?
The payment was for the food, but ultimately the price went to the date.
The allotted time has elapsed for cross-examination.
I'll allow the 15 seconds that's still up there, but this will be probably the last question, counsel.
Ms. Nixon, to make it clear for the court, you canceled my client's food before his final payment was due?
Objection, Your Honor, under 403.
Could you explain?
Yes, Your Honor. This is substantially more prejudicial than probative. What opposing counsel is trying to say in this instance is that there was a fee 30 days prior to the event, but the event never occurred.
Okay, any response from the plaintiff's counsel?
Yes, Your Honor. The probative value of this question goes to the fact that the defendant has alleged that my client breached his contract by not paying this fee due 30 days before the event date. However, the plaintiff's case today is that the defendant broke the contract by repudiating that. The way they repudiated that was saying they would not be providing food to my client, which they did 2 days before his final payment was due. The probative value of this goes to show the order of events and that the Nixon Lodge repudiated their contract before my client's payment was due.
Okay. Anything else, Ms. Garrison?
Yes, Your Honor. Although there was a rescheduled date, the June 4th date was still when this was due because the rescheduling date hadn't occurred yet. This is substantially more prejudicial than probative to hear this information.
Okay, I'm going to overrule the objection and the witness will answer.
Ms. Nixon, that's a yes to my question that you canceled my client's food before the payment was due?
Yes, that's
Objection, Your
correct.
Honor, substantially more prejudicial than probative under separate grounds this time.
What's the separate grounds?
The separate grounds this time, instead of to the date, Your Honor, is to the food. Other witnesses have made this very clear that all of the fees were for reserving the event date. The food was never a part of this. That is how the Nixon Lodge deviated the finances given to them. It is substantially more prejudicial than probative to hear that this was going towards food.
Okay. I'm going to overrule the objection. And the attorneys in your closing can argue whatever you think the facts might show and how the jury should look at it. But I think we already have the answer to this question, but let's go ahead and ask it one more time and get a definitive answer, and then that will end the questioning.
Ms. Nixon, that's a yes to my question that you canceled my client's food before his final payment was due.
We canceled the food, but again, the payment did not go towards the food. Ultimately, it went towards reserving the event date.
Ms. Nixon, that wasn't an answer to my question. To be clear, this cancellation of food happened before the final payment was due?
Yes, the food was canceled, but the money went towards reserving the event date. And I understand the confusion.
Ms. Nixon, I'm not asking you what that money went towards. I'm asking you It's a yes to my question that you canceled my client's food before his payment was due. Can I get a clear answer on that, please?
As I said previously, yes.
Thank you, Ms. Nixon. No further questions, Your Honor.
Okay, Ms. Garrison, any other redirect based upon that cross-examination?
Yes, Your Honor. May I proceed?
We just need your timer, your timekeeper. Okay, thanks.
Ms. Nixon, the plaintiff started their opening statement by talking about a couple different C words, but I want to talk to you about those. Why did the catering change?
The government restrictions required us to change the way we
Objection,
catered.
Your Honor. Unfair extrapolation. May I be heard?
Yes.
Your Honor, in Exhibit 3, specifically the part of the section that includes the government's restrictions, there is no mandate for the Nixon Lodge to have canceled their food. And for Ms. Nixon to say this is an unfair extrapolation under Rule 2.2.
Ms. Garrison, can you point to any spot where the government restrictions dealt with that?
Yes, Your Honor. In cross-examination, we explained this direct examination, we explained this exact instance. We explained that there would be a problem with a buffet and served dinner because of, I will find the right page. It is page 63 of the case materials, 4307.0060 preparedness plan, subpart 2B. Maintain social distancing of at least 6 feet between staff and mandate face coverings as required by executive order. Ms. Nixon is simply explaining that because of the 6 feet requirement, the served food and buffet options weren't possible. That is within the government restrictions.
May I respond?
Yes.
Your Honor, this government restriction mentions nothing about catering. To extrapolate that this government restriction, mentioning nothing about catering, meant that the Nixon Lodge legally couldn't have catering is an unfair extrapolation.
And I believe that's an appropriate argument that both sides could make during closing arguments. I'm going to overrule the objection.
Ms. Nixon, why did the catering change?
Again, the government restrictions required us to change the way we did catering because of the mandatory mask wearing and social distancing.
Why did the capacity change?
Once again, the government restrictions required us to reduce the capacity.
And why did the cost of this event stay the same?
The deposit was going towards reserving the event date, which we did. We reserved multiple
Objection, Your
dates
Honor.
for...
Beyond the scope of my cross-examination.
Ms. Garrison, is there an area that you believe this goes to as far as cross-examination?
Yes, Your Honor. Over cross-examination, opposing counsel talked about multiple restrictions and things that they weren't able to provide. One of the things that was talked about is catering and capacity and mentioned the rescheduling fee. This is attached to the rescheduling fee.
Anything else from the plaintiff?
Yes, Your Honor. Ms. Garrison just asked whether or not why the cost for the event did not change, something that I did not address during my cross-examination.
Okay, I'm going to sustain the objection.
Yes, Your Honor. Ms. Nixon, in relation to the rescheduling fee, is that within the contract?
Yes, it is.
No further questions, Your Honor.
All right, thank you. Because the plaintiff is out of time for cross-examination, that will conclude the witness testimony. Thank you, Ms. Nixon. You can step down. I'd like the timekeepers to go ahead and put 2 minutes on so that we can have just the attorneys talk with each other in preparation for closing arguments. And we'll be back at that time. Thank you, everyone.
Point of order, Your Honor, the time has elapsed.
All right, thanks. If I could have the attorneys doing the closing arguments, come on. Come on to the screen, thanks. Is the plaintiff ready to proceed with its closing?
Yes, Your Honor.
And is the defense ready to proceed? Your volume's not working, just so you know.
Yes, Your Honor.
Okay, great, thanks. And now that we got your volume working, you can mute yourself. Thanks. We'll go ahead and hear from the plaintiff, please.
The 4th of July, 2020 was supposed to be the happiest day of Peyton Knox and Parker Stevenson's lives. They spent months planning their perfect wedding with all the right food and decorations. They saved up and paid $70,000 to Nixon Lodge so they would host it. That wedding never happened. And ultimately, it wasn't because of the pandemic. It was because of Nixon Lodge and their unreasonable restrictions. During opening statements, my co-counsel, Mr. Long, asked you to focus on 3 of these in particular. These are the catering, the capacity, and the cost. But before I discuss these in detail, I'd like to first look at the law. Peyton Knox is suing Nixon Lodge for breach of contract. Both parties signed a contract for the July 4th wedding. By bringing this charge, we've taken on a burden. We had to prove, more likely than not, that it was Nixon Lodge, not Peyton Knox, who broke the contract. And we have met our burden. Because you've heard that Nixon Lodge broke the contract time and time again. Now, I'm sure that Ms. Gord will try to justify this using the force majeure clause. She may tell you that this clause would absolve her client's responsibilities during the pandemic, but this isn't the case. The clause still clearly requires that Nixon Lodge put forth reasonable efforts. But you've heard what their management did, or rather, what their management didn't do. Ms. Nixon neglected to communicate for months at a time. Mr. Olivia neglected to upgrade Nixon Lodge's unsafe ventilation. Nixon Lodge neglected to put forth a reasonable effort to uphold the contract. Instead, they breached it 3 times over in regards to the catering, the capacity, and the cost. Let's first look at the catering. Mr. Knox paid top dollar for the top food that Nixon Lodge had to offer. Just a month before the wedding, Chris Nixon emailed and canceled all of it. Now, it would have been one thing to cancel shared finger food during a pandemic, but Nixon Lodge went too far. They canceled dinner, drinks, hors d'oeuvres. They canceled everything, despite the fact that serving food was still safe and legal under Department of Health guidelines. The money Mr. Knox paid was to ensure food. Ms. Stewart admitted this on cross-examination. She also admitted that she ordered the food because she didn't know it had been canceled. And now, Nixon Lodge is countersuing for the rest of the catering fees. But they canceled the catering before these fees were due. Mr. Knox was not responsible for paying for non-existent food under the terms of a broken contract. Next, let's look at the capacity. Mr. Knox paid for 250 of his friends, family, and colleagues to attend his wedding. You've heard that the capacity had to be cut down, but the question is how far? The Department of Health cut it down to 175. Nixon Lodge cut it down to just 75. That's 100 people Mr. Knox had to cut out of a special day for no good reason. When the defense cites their ventilation issues, remember that they had months to improve their ventilation. Instead, they did nothing. They could have hosted more guests. They chose to host less, and by doing so, they breached the contract again. Finally, I'd like to look at the third breach, which is cost. Chris Nixon demanded an unreasonable rescheduling fee. Mr. Knox had already paid for his beautiful July 4th date. When the defense sprung new restrictions just a month before, he tried to reschedule, just hoping that things could still work out. In response, Ms. Nixon offered a weekday in October. The price for the downgrade was $3,750. This fee was not allowed in the contract. The defense has cited a transfer of service clause, but this clause states that the new fee had to be based on the event date, and the new date was worse in every way. It wasn't a Saturday, it wasn't in the summer, it wasn't a holiday or the couple's anniversary. A fee for this date was a breach of contract. Members of the jury, I'd like you to consider everything that Nixon Lodge did since March. I'd like you to consider the months of no communication and refusing reasonable efforts. Consider the undue changes to the catering, the capacity, and the cost. Members of the jury, consider all these things and find Nixon Lodge liable for breach of contract and the plaintiff not liable for the same.
All right, thank you. Whenever the defense is ready, you may proceed.
If you could just give me a brief moment to set up, Your Honor.
Certainly.
May I proceed?
Yes.
The plaintiff told you that today's case is about capacity, catering, and cost, but they forgot about the most important C, the contract, and the Nixon Lodge followed the contract. Members of the jury, in response to the COVID-19 pandemic, the Nixon Lodge was faced with a tough decision. How could we continue to host weddings safely? And the answer was reasonable restrictions. Today, the plaintiff had the burden of proving by a preponderance of the evidence, meaning more likely than not, that the Nixon Lodge breached the agreement when they implemented these reasonable restrictions. Now, did the Nixon Lodge perform every single item in the contract exactly as described in the contract? No, they didn't. But that is not the standard. The question we really need to be asking ourselves is, does the force majeure section of the contract apply? And the answer is a resounding yes. In order to prove that the force majeure section of the contract applies, we needed to prove two things. One, that COVID-19 qualifies as a force majeure event. And two, that the Nixon Lodge made reasonable efforts to comply with the terms of the contract. So let's start with one. It's clear that COVID-19 qualifies as a force majeure event because of the specific language in the contract. The contract calls a force majeure an event, quote, beyond a party's control. Members of the jury, COVID-19 was obviously not caused or controlled by the Nixon Lodge. We have proven that the COVID-19 fits the exact language of a force majeure as defined in the contract. So the only thing left for us to prove was that the Nixon Lodge made reasonable efforts to follow the contract. So let's now go through the evidence and evaluate all the ways the Nixon Lodge did just that. First, the Nixon Lodge took the necessary safety measures required to be able to host the wedding. The Nixon Lodge consulted with scientists. That was reasonable. They consulted with health inspectors. Also reasonable. They evaluated airflow at the lodge. They developed a preparedness plan. Both are reasonable. They required masks and social distancing. They purchased face coverings and face shields and gloves and disinfectant. These are all reasonable. Members of the jury, these are all examples of the Nixon Lodge responding to the force majeure situation and doing everything they could to perform on the contract. This is exactly what the force majeure section required the Nixon Lodge to do. And it's not just safety rules. The Nixon Lodge was still following section after section of the contract. When the plaintiff requested a date change, the Nixon Lodge performed on the contract. The Nixon Lodge offered not one, but two alternative dates. And it's not just a transfer of service section. Here's the contract. You can read it yourselves. Look at all the sections the Nixon Lodge followed. Outside vendors, pets, deliveries, security. The Nixon Lodge was still following section after section of the contract. This is exactly what the force majeure section required them to do. Now, the plaintiff has tried to claim that the safety measures the Nixon Lodge took were all unreasonable, but that's just not true. Every single safety measure the Nixon Lodge took was a reasonable restriction. Now, my opposing counsel argued that the Nixon Lodge went above and beyond the government restrictions by imposing a limit of 75. But this is flat out wrong. Here are the restrictions. In the very first paragraph, it is recommended that venues have 0 people at weddings. 0. The Nixon Lodge actually provided 75 more than the government recommendation. What the plaintiff kept quoting today was a maximum, not a recommendation. The simple fact is that Peyton Knox and Jordan Knox and Riley Swain are not qualified to tell you how many people the Nixon Lodge can have at their own venue. They have no knowledge or education, and blindly following a maximum is not reasonable. Members of the jury, you can think about it like a speed limit on a highway. Is it safe to just blindly follow the speed limit on a road no matter what? Of course not. If there's snow or ice or fog or even a flat tire, going the speed limit can be dangerous. What a reasonable driver does is select a safe speed after evaluating all the conditions. That's what the Nixon Lodge did here. They didn't just blindly follow a maximum. They consulted with scientists, evaluated their lodge, and came up with a safe number to keep guests and staff safe during a pandemic. The 75 limit was reasonable. The plaintiff also argued that the Nixon Lodge was being unreasonable by not allowing dancing at the weddings, but this argument makes no sense. Their own witness, Riley Swain, admitted that the law requires people to remain seated with no mingling. All the Nixon Lodge did with this restriction was follow the law. The restriction on dancing was a reasonable restriction. Their argument on dancing is even worse when you look at the contract. The contract states that the Nixon Lodge is not liable for any claims of loss of enjoyment. This is yet another example of the Nixon Lodge following the contract and the plaintiff breaking it. They next tried to argue that it was unreasonable to consider the ventilation system for an outdoor wedding, but you were provided with a perfectly reasonable explanation. In the event of inclement weather, the wedding needed to be able to be moved inside and safely. In fact, the contract requires that the Nixon Lodge limit the impact of inclement weather. Once again, the Nixon Lodge was following the contract. Now, they also kept claiming that the Nixon Lodge was charging for food that they were not providing. But once again, this is not true. The contract is very clear. No money was ever paid for truffles or food. All of the deposits are for reserving the event date. And once again, the Nixon Lodge performed on the contract. The plaintiff also argued that the restriction on food went above and beyond the government recommendations. But once again, this is simply not correct. The government rules require venues to ensure 6 feet of social distancing between staff and guests. And that is simply not possible with a buffet and served dinner. It's also important to remember the timeline. The Nixon Lodge implemented these restrictions in June of 2020. The coronavirus was still brand new. It is certainly reasonable to err on the side of caution and prohibit a buffet for 75 people. This was a reasonable restriction. At this point, I want to remind you of the standard. We had to prove that the Nixon Lodge took reasonable actions to comply with the terms of the contract, and we've provided reason after reason after reason that they did. The Nixon Lodge implemented reasonable restrictions in response to a vicious virus. Find them not liable. Thank you.
Thank you, Ms. Gort. Mr. Murnoskin, you have a couple of minutes left, I believe.
Yes, Your Honor.
Would you like to make?
Yes, Your Honor.
You may proceed.
Ms. Gort has told you about reasonable restrictions, but Nixon Lodge's restrictions were far from reasonable. They cut the catering, they cut the capacity to 75, they raised the cost for rescheduling. None of these were required by Department of Health guidelines. None of these were allowed under force majeure. None of these were allowed anywhere in the contract. Find the defense liable for breach of contract and the plaintiff not liable for the same.
All right. Thank you, counsel. Okay, folks, congratulations. You're done. I'm going to give you all just a minute to consult with each other to see if you want to request any point deductions. And so if I could have the timekeepers go ahead and put a minute up, I'd appreciate it.
Your Honor, the defense would actually be perfectly fine waiving this time if the plaintiff is comfortable. If not, we can keep the time.
Why don't we go ahead and take the time? I appreciate it, but it's just a minute. Okay.
The time has elapsed, Your Honor.
All right. Thank you. If I could have an attorney from each team appear. Thanks. Is there any point deduction that the plaintiff would like to raise?
No point deductions from the plaintiff, Your Honor.
Okay. Anything from the defense?
No, Your Honor.
Okay. All right. Now we're done. We're going to break away for a little bit and we'll be back. Thank you. And congratulations to all of you.
So judges, I think if you go ahead and click on join the breakout room, you should go right in there. So Judge Fisher and Winnie.
I wanted to just thank our opponents, Apple Valley, for this trial and this competition. It was really great and really eye-opening, and I learned a lot, and I had a lot of fun competing in the state finals against you guys. So thank you for that.
I agree. I wish both teams the best of luck, whatever comes next.
Thank you guys so much. We really appreciated. Oh, my mic is not on. I'm so sorry. We really appreciate all that you're saying. It does mean a lot to us, and we did enjoy competing with you guys as well.
All right, if I could have my other judges go ahead. You can turn on your video, judges, please. And part of me wants to have all of the students turn on their video just so that we can see everyone. So if you don't mind doing it, folks, we're going to go on multiple screens here and we'll have lots of tiny little tiles. It keeps populating here. Okay. That's all I can see on my screen. First of all, on behalf of all of the people who have been involved in the program, we judges get to have the pleasure of coming in and watching the fruit of all your labor. You've put a lot of time into this. It's very clear to all of us. And it's interesting because we typically judge all the way throughout the season. So we see how arguments might change and evolve and how people become more comfortable with the facts and the law. And I can tell you, it's really impressive. We appreciate all the effort that the students have put into this. And as we said earlier, we thank the coaches and everything. Also family members for supporting your students in this endeavor, especially during Zoom times. It's been interesting. I would also like to just thank Kim. I don't know if Kim's on. Kim Basing. She's our glue. She's the glue. She's the backbone. She's the heart. She's the soul. There she is. I mean, I would like applaud her. You all have an inkling on what it's like, but Kim and a couple other staff members at MSBA have the Herculean task, basically, of when we have our rounds, trying to coordinate dozens and dozens and dozens of teams that each have a dozen people, and then have all of these judges coming in. And we've never done Zoom before. You would not know it by how smoothly everything ran this year. It's really been easy from a judge perspective. And it's all because of the work that Kim does throughout the year to work with schools and everything else. And so Kim, thank you very much.
Thank you.
For everyone else, I can tell you we had a very good conversation when we broke away and we were talking about your performances. There were highlights that we kind of pointed out from both teams and things, both with the attorneys and the witnesses. You brought kind of a good, fresh perspective to a couple of things, and I like that a lot. We all did. Of course, this is the championship round. And the championship round means that one team did better than the other team. Do not be disappointed if you came in second, because there weren't only two teams in this competition. To get here, you had to survive a lot and prevail a lot. But obviously today, only one team can be named the winner of the mock trial competition for the state of Minnesota. Are you all ready? Okay. I kind of want to have you all take your mics off and do a drum roll together. So take your mics off. If you're near a desktop or something, do a drum roll. Make it loud. Okay, I didn't hear any of you, but hey, the winning team is Eagle Ridge Academy. So congratulations. We're all very excited for you, and all of you can be very happy with your work. And I think that's it, unless Kim, if you're still there, or Winnie, do you have anything that you want to say as the chair?
No, it was just a pleasure, you guys. It really was. You were all spectacular. We hope to see you next year. Hope to see you in law school in the future. I do teach at a law school, so if you ever have any questions, you're welcome to send me a message and ask about that. And nationals will be coming up, but in the meantime, I hope that you guys really celebrate and have a really good time. And even literally everybody on here deserves to celebrate big tonight. So congratulations, you guys. Cheers to all of you.
But socially distance.
Yes. So what I would like I'm sorry, Judge Cook. So what I would like is for the Eagle Ridge Academy students to have their faces on. And of course, all the judges, I would like to take a picture for our Bench and Bar magazine, since we aren't together and we can't hand a trophy out to you. So I need to get a good picture
Look
with
good,
all
everyone.
of the coaches included. Everyone on the team, please have your camera on, and I will count down and then I'll take a picture. Thank you. All right. 3, 2, 1. Let me take one more, guys, just in case that one didn't turn out. This is so different to do it this way. Give me one. I'm sorry, guys. I'm just moving very slow. I'm on very little sleep.